in an exceptional matter like this, look at the entire literature and masters across the world. Everybody talks about the Bhopal gas matter.
Yes, maybe.
And therefore,
have you disbursed all the amount which has been deposited?
Yes, I'll give a complete detail on all that. What happened, what expenditure happened. I'll give a complete detail.
The money which has been deposited over these as a part of the settlement, does it fully stand disbursed or not? Fact.
All that is available, we have placed that on record. We fully disbursed. Beyond that disbursement, the government of India had taken a stand to make an additional escalation for all that has happened. I place on record details of expenditure.
Also, is the funds all utilized now? Or?
Yes. That is a complete set of information available. But what we learned from the objection is the interveners, who were the original petition, many of them, have placed on record certain documents. I want to personally find out whether they can be taken on record as other documents. Some of them I have some question, but nevertheless, in order to place a complete picture before the case, they've been placed.
Please address us how we can take these documents on record.
At some point, Bernard, I just wanted to say one thing. Because not just admitting these documents, the Lordship will have to first decide to construct in which this matter is to be done. For me, this is not an extraordinary case. There was a suit filed by the Union of India. In the suit, an interim order was. That interim order came in appeal to your Lordship's court, in which the Union of India and my client, UCC, settled. There is a settlement decree. The suit was disposed of. The review petition doesn't say set aside the settlement, because if the settlement is set aside, I am not willing to pay even a farthing. I can't be directed by a court in a 5-judge bench hearing a curative to say pay more. My liability has never been established. There is a consent decree. If there is no consent decree, if the decree is set aside, first of all, your Lordship will have to be shown on what legal principle the decree is set aside. And if that decree is set aside, the suit restores. And if the suit restores, consequences will follow and the suit will go on. This is not a case where my client agreed that as and when more data comes, please feel free to add to my liability. On the contrary, in the review petition, one of the grounds taken was that this settlement is bad because there is no reopener clause. Your Lordship said, yes, there is no reopener clause, but that doesn't mean that the settlement is bad.
So sorry.
1 minute.
Sorry.
The point, therefore, is please see the settlement. If there is no reopener clause, then the Union of India must say, we don't want set aside this decree. Then we will see where we are. And if that can't be done, all these documents to show that the Union of India should never have settled for so much is not something which your Lordships at this stage should be troubled with, unless I don't know what case do I have to answer. Do I have to stand here and say there is a mass tort case? Your Lordships are exercising your Lordship's original jurisdiction. It's an extraordinary original jurisdiction, in which your Lordship will first try my client and hold my client is liable, and then pass a decree, and then take all this evidence on record without any testing or cross-examination, and pass a decree on my client. So, it can't be like a public forum debate saying here is all this data placed by all these NGOs, and now I can show you so many more people died. There were so many more injuries. Government of India got it horribly wrong in estimating the figures. Government should never have settled. So please pass a judgment against UCC, doubling, trebling, 100 times more of the original settlement amount. My client is not willing to pay even a farthing. We are saying this is what he settled. If you don't want the settlement, set aside the settlement. Let the law take its course. That is going to be our submission. So, and that is direct bearing on what documents you should look at.
I'll try to address all these questions. I don't know whether your willingness to pay or not is not the final word on the subject.
No,
if you walk away with a corporate...
Attorney, what he says is that if in a settlement he is paid X amount, correct? Can you say, normally these are extraordinary circumstances, but normally if somebody would try to walk out of a settlement, you say the benefit of the settlement must come back.
Yes.
Then you talk about it. So therefore,
I would probably go along the direction that we are not asking for a settlement to be annulled at no point of time, even though arguments were advanced during the review and earlier and some later applications filed. please have a close look at the settlement. Did it bring about a just conclusion to the whole issue? In
Settlement
that
is by
context,
two parties.
my submission.
The settlement is by two parties.
Yeah.
In that sense, the court doesn't step into it and say, why did you settle? And one of the parties, Union of India, it's not a weak party that somebody can say, oh, there is an oppression and there's a weak party who is settled.
I quite take that, but
Therefore,
look
what
at
has been troubling, and we've been trying to discuss with Sir, what is
I-
the scope of this kind of a curative petition? And after this period of time, in view of conduct, maybe you are right that this was, in your perception now, not the best of the settlements. You should have got more for this settlement. People should have got more for it. Can we reopen it?
No, I would be probably endeavoring to do that in the sense that we're not asking for annulling the settlement. But there are always situations when courts have amended a settlement, added to a settlement, if the justice of the cause demands that. I'm going to proceed on those lines. We're not asking for a settlement being annulled. And if I'm able to persuade your lordships on those lines.
It's not an issue of division of property that somebody will get a little more or less. That's not. It's a claim, tortious claim.
Yeah, that's
In a
true.
tortious claim, both parties settle. Having settled, is it open for one of the parties, that also Union of India, to say, look, I did settle, but I think I should have settled for more, or more should have been forthcoming. On that, whether other NGOs can write piggyback on that concept of a curative petition.
But
I'd be able to link all those dots. That's what
I'm sorry,
I
I only brought up.
I'm only trying to
understand. I know.
put a perspective in place as to, for us also to appreciate what is the contours of submissions. which
Very
we
true.
make.
There are some unexplored dimensions of law in this case. Probably, if the lordships go along with this proposition, we'll be probably looking at a way of looking at it entirely different from how it's been looked at earlier.
But Malad, I assume the attorney would then give us something in writing of these unexplored dimensions, because his curative petition doesn't tell us what dimension.
It indicates.
I take it he's not going to then go beyond anything said in his curative.
How can they go beyond curative?
But Malad, I'm sorry, everything which has been filed before your lordship is unrelated to the curative.
But then we permitted all that? No, we flagged it in the beginning.
I'm so sorry, I raised this point at this point.
Yeah.
Like, till we know what is the construct of this
See,
case.
when he, honestly, when I have no problem with it, he had arranged a compilation of record in such a manner that it would facilitate in our hearing the curative.
Absolutely. Your lordship's order was.
Absolutely.
Your lordship's order was NGO's documents are not to be taken on record. Union and Union Carbide, Union of India and Union Carbide, the two contesting parties, will give a joint compilation.
Joint compilation is always of what is on record.
Exactly.
In a curative level, you
We
can't.
we tried sitting with them, but we were not entertained. Their application.
I had your instructing counsel sitting with me. I cleared those documents. I looked into them.
They then had meetings, obviously, I'm reading from their application for condemnation. They had meetings with the interveners. And a number of interveners' documents, which are part of the interim applications of the interveners, which are not on record, are now put before you. And they have.
So the first question is, are we or can we look into what is not part of the record already? I'm absolutely clear what our intent was when we said compilation. Our intent was record becomes very, very in these things becomes very haphazard.
Waste of time.
Number two, and also more so because it's the curative, very limited scope. We are not required to look into 11 volumes. Therefore, take out of the 11 volumes what you feel is relevant for curative. That is
I have done an analysis of the indices of these volumes.
Let me have the benefit of the analysis.
Of course.
And if and may put it like this.
Your Lordship, just.
क्या करते हैं हम?
Attorney for you. So,
Page 120 of the main violation, paragraph 198 of the review judgment. 198 of the review judgment.
This is curative petition.
Main compilation of the curative petition, volume 1.
Yes.
Because the review judgment holds that if there is shortfall, it is the duty of Union of India to pay the compensation. That's the question we want to ask you. Just see page 198. Paragraph 198 on page 120. That's the review judgment.
Kindly just read it aloud so that
Our submission. There is a settlement.
Just a minute, he's not getting it. Please see volume 1. Volume 1. Volume 1, page 120.
one it
1991 4.
3rd October 91 judgment
it's a para 198 of the second judgment which you left.
and SEC reference page 682.
I just come. The paragraph beginning.
After a
after
careful
careful
thought.
thought.
Yes.
Yeah.
It appears to us that while it may not be wise or proper to deprive the victims of the benefit of settlement, it is however necessary to ensure that the perhaps unlikely event of the settlement fund being found inadequate to be the compensation determined in respect of all the present claimants. Those persons who have their claims determined after the fund is exhausted are not left to fend for themselves. But such a contingency may not arise having regard to the size of the settlement fund. That is, however, a hypothetical situation. If it should arise, the reasonable way to protect the interests of the victims is to hold the Union of India, the welfare state, and the circumstance in which the settlement was made should not be found wanting in making good the deficiency, if any, be voted and declare accordingly.
Only. So
We
what
have
is
some
what? So
question
that,
about that.
there are two aspects of it. One aspect is that therefore I asked the first question, which arose from the statement if the fund is exhausted. Now, it does appear from the last time, my recollection is of the last state's hearing, where it was pointed out by the council that there are still funds lying deposited by Union Carbide which are undisbursed. They say 50 crore, you will be able to answer what is the amount. Therefore, when the funds are lying with you, it's not a question where funds are exhausted. One. Even 25 years down the line.
There are some parallel writ petition
I'll
filed.
put it slightly different, if you got.
No, I let me put it and answer it
Right.
your way.
Yeah.
This is one. aspect.
I try to look at
Yeah.
both, varied points of it. I mean, it's not as if.
This is one. Secondly, what my brother rightly points out is that were the funds to fall short also, you are the one in Union of India, you have to make it up.
There are in the curative petition and in the documents which are filed in support thereof, the argument is that there are three claims by Union of India which is set out in the curative petition. So under each of the heading, we find that the amount which has been made over to us under the settlement fund is inadequate. Number one. Number two, the figures on the number of deaths and the categories of injuries, permanent, temporary, etc. The figures have gone much beyond what the review court found at that point of time. That's why they say present claimants. If the figure of deaths was 3,000,
How come amounts are still lying?
and it's really more than 5,000.
How are 50 crores, if at all, lying undisbursed, which means people are not getting the money?
No,
Are you responsible for the money not going to the people?
I see that. That's why I tried to look at the angle. What was the total corpus of money available from the settlement fund and how it has been expended? That's one aspect of the matter. But at the point of time when the review judgment came to a conclusion that the present claimants and the fund is adequate to meet the claim demands of the present claimant, we were able to show that it is not so. The number of claimants as determined by the welfare commissioner have gone beyond what the review judgment had in mind. Therefore, that's a basis for your lordship being asked in the curative petition to go beyond the review judgment.
I think
to
the
find out
correct thing would be, let us see your curative petition first. What
But
is the
I
curative
just want you to
petition
make one little.
Because
And
these are all figures.
Yeah,
please
that's the
address
starting
us-
point.
Please address us why and how, according to you, not having filed a review or curative is.
And my lord, please,
I have one more submission to
your
make,
lordship
which I-
is not taking these on record, their compilation.
We have not as yet taken into.
No, I would probably suggest whatever objection.
We have neither said
we
yes
let me
nor
look at
said
it.
no at the moment.
Because these are just exchanges. I try to look and find out. I'm told many of the documents which objections are being raised have been played by the interveners earlier than pointed out, soon after the curative petition was
See,
filed.
we can't.
They were petitioners and they intervened in the curative petition.
May have.
Therefore, if
Today's question is your curative petition.
it's my
We
curative
can't let,
petition,
and
but-
your curative petition is not, is it or is it not?
I would
It's not preceded by a
probably-
review. There are many, actually all we are pointing out is, there are many hurdles in your way. You may be able to cross it, yet we don't have any.
so there are, see,
Just to finish this point.
in both in the settlement judgment and in the review judgment, and in some of the interlocutory applications filed over a period of time. And just look at these cases when the act was put a challenge. A post-decisional opportunity to the claimants, I think, is desirable, has been emphasized in more than one place. Therefore, if the act has to some extent considerably removed the claimant's voice being heard in the most requisite way, and if that's how it should be done, and if the review judgment, according to my reading of the review judgment, it has left open a considerable avenue and a window for a court to relook at the settlement corpus. And if that is open, I think documents will throw considerable light on the various facets of the case will have to probably receive unless the serious objection to the sources from which you got those documents.
Not so
The process by which you obtain
You
those.
have to link first. You have to subject to whichever way you want to go about. First, you have to say, it's in my thinking process, how a curative petition without ever having filed a review petition would lie. One. Number two, what is the scope of this curative petition? Then we'll come to whether any further document can be taken.
To put it shortly, if I'm probably able to take it out from these lines, if the Huda judgment had in mind a certain set of circumstances post anthole, the writ petition being filed to reopen settled judgments of court, either in the special petition, the appellate jurisdiction, or even into jurisdiction, Naresh Vidaskar onwards. So if the court had that in mind, principles of natural justice. So I'm probably able to tell you, Lordship, that principles of natural means a fair hearing. A fair hearing means, like what Justice Ahmed said in the Allahabad High Court, that if a record of a case were not before the court, there is no fair hearing.
So, according to you, government did not get a fair hearing, or the government did not know how to give a fair hearing to others?
I've only brought a
Curative is a very yes. This is a door or a window which has been
No,
opened,
maybe.
but it is every year closed for 200 cases. Hardly anything comes out of it, because there must be some very rare and compelling circumstances.
I'm in complete agreement with
under
that.
which
But
it has to be
in a
exercised.
case of this nature, which defies several logics of the due process of law, and where therefore the court will admit certain routes, certain processes.
But you are
be part of the
arguing on a
Huda
basis. You are arguing on a basis you don't want to open the settlement, because you are in a you have many slippery areas. If you say that they open the settlement, that will create its own complications.
I've also looked at those other instances, for instance, US litigation, the asbestos litigation, etc., where the courts have always left like the reopening clause. I mean, in some settlement, there is a reopening clause. That does not mean if the reopening clause is
there-
not there,
Is there
the ends of
reopening
justice
clause?
will close that.
No, here the clause is, well, if a situation arises to increase the claim, you do it. That's what.
I take a lot to some of the observations in the review judgment
Mhm.
and say that yes, there was a
This-
concern,
On
an
the
underlying concern.
on the settlement, para 199
119.
and 200 of the same judgment.
No, I would probably, these are just broad
Kindly
reflection.
just read 199 also in the sequence.
Probably, I'll read that.
Next paragraph.
I'll read that. It is relevant here. The Union of India quite fairly all these fact settlement powers sought to assail his validity on certain legal issues. But the factum of the settlement was not disputed. Indeed, Union of India did not initiate any substantive proceedings of its own to assail the agreement of the consensual element constituting the substratum of the order of the court. The legal contention as to the validity of the settlement is permitted to be raised in as much as that an order made on consent would be at no higher footing and could be assailed on the grounds that an agreement could be. And, but that I stated earlier, the factum of the consensual nature of the transaction and the existence of the fact was not disputed. Those legal contentions as to the validity have now failed. The result is that the agreement subsists. I've seen that. But I would probably be able to urge your lordship that if in other parts of the judgment the court has expressed its concern, if there was a need to look at on the basis of emergent facts, which emergent facts are beyond dispute, if you put it like that, then this will not come in my way, neither in the way of the Union of India, nor in the way of the petitioner who have legitimate claims to demand the settlement to be amended. We're not asking the settlement. The court will find, yes, the number of figures that you shifted to amend the settlement. It doesn't depend, your volition. It doesn't depend on anything you want to do. Look at the way the whole transaction happened in 1991 as a review judgment. Your corporate games people always play, restructuring the internal structures. So today, the United Nations laid down certain guidelines on how human rights concerned. It is certainly a factor to be taken into account for looking at global commerce and global trade, multinational enterprises. The emerging trend of views looking about how to look at that. Therefore, it's not as if you're looking at an isolated tort case where somebody will have a private liability issue to be determined and walk out of that. For certain diamonds, what I like to present your lordships.
Okay.
I'm anxious. Thought has gone into
Let
it.
him,
I know there are some difficulties in it.
let
But
him
if I'm
proceed
able
with it,
to-
otherwise we'll
I just want you to get one thing clear. Would your lordships, because where we are today, would your lordships see your lordships orders of February and April 2011?
Yes.
Some confusion was created. We want to be very clear.
Which order are you speaking to?
If your lordship is pleased to turn to the first order of February 2011.
February 2011.
It's 28th February 2011.
Yes.
It says, generally in curative petitions, hearing in court is not guaranteed. However, looking for the larger public interest in the petition involving substantial question of law, we have decided to hear these curatives in court. 345 transfer petition, issue notice, custody in addition, etc., etc. Then, and there were two curatives. One was the criminal curative, one was the civil criminal that has been dismissed. Then, on 13th April 2011, it's another order where the pull and push of the hearing before the court started hearing the criminal matter. At page 3 of the order, there was a notation saying interlocutory applications 7 and 9 are allowed subject to service.
Yes.
Now, we mentioned the matter and saying this wasn't accurate. And so on 13th April 2011, your lordships added the sentence. In the 13th April 2011.
Yes.
If your lordship sees, this is the revised order, interlocutory applications are allowed, issue notice on the maintenance of interlocutory applications and the merits of the matter. So first of all, maintainability of the merits of the matter needs to be gone into. Then the maintainability of the interlocutory. And that's where we are. And on that basis, my lords made an order on the last occasion where your lordship said there is no liberty to find anything beyond the record of the curative beside the primary issue.
Yes.
And our position is very simply as follows. There is a settlement. Now, there is no reopener clause in a settlement. Of course, the attorney is going to show your lordship jurisprudence saying 30 years down the road, because of corporate games being played, the court can rewrite the settlement and get my consent. And my consent is unnecessary, it will still be a settlement. However, whatever else there may be, one important jurisdictional factor your lordship would know. And I just want to place it because we put this on as not only was curative jurisdiction unknown when all this started, that nothing much may turn on. The Union of India filed a suit in Union. Union Carbide applied for transferring the suit to India on the principle of foreign non-convenience. The question was, would Union Carbide, an American company, which had no presence in the Union, abide by the jurisdiction of an Indian court? Judge Keenan's order, our undertaking with the record is that we will abide by orders in the suit. And that is how the suit started. The suit was at an interlocutory stage where an interim order was made, the matter came here and the case got settled. Today, I am not facing any judicial review proceedings or an Article 32 proceeding by somebody saying, you're a multinational, you're a bad boy, you should be asked to pay more, because then the question would arise, if notice is issued, will Union Carbide accept service? It's an American company, it may accept your lordship's jurisdiction, it may not accept your lordship. So it can't be in a framework of this kind, where it arises out of a suit. We bring in some principles of constitutional law, etc. Our position is, and I'm just stating it, and then of course the attorney will assist it. Our position is as follows. There is a settlement between the parties. Now, one party is telling the lordships, I was hopelessly ill-informed in arriving at the settlement. That's at the highest court. And there were elements in the settlement. Relief and rehabilitation was expressly excluded from the settlement. They are now asking for relief and rehabilitation, that it should have been part of this. We are saying we have not agreeing to revising any settlement. I'm not saying whether my permission is required or not. I'm saying I'm not agreeing. Now the question is, what in this curative petition would your lordships be doing? The point which your lordship will have to cogitate first. Are your lordships exercising some extraordinary jurisdiction in which your lordship will say the settlement shall not read this way, but the settlement will read differently, and you are deemed to have consented? Or your lordship will say, we don't need your consent. We are now passing a decree in the suit without there being a trial, some principle. And I don't know what principle there, because in the curative petition, it only states this is the settlement, these are the figures, this is the amount, therefore. What legal principle it sits on is not clear. We ran this point in the counter in pages and pages and pages of the counter. And a rejoinder is filed by the Union of India. And I just want to show that, and I'm done, then not the attorney. Because I am saying, I don't know. What is the case I'm facing? When I ran this point in the counter, and I won't waste your lordship's time reading it, your lordship will take it in pith and substance. This is the defense we raise, saying this is a consensual arrangement. You can't unilaterally say. There is a rejoinder filed by the Union of India. I don't know where it is. Where it is.
What does it say, Mr. Salve?
Yes, I'll read out 2 or 3 paragraphs. It says, the petitioner has not given any appropriate reply except stating technical objection. Technicality should not defeat the dispensation of justice. Settlement was done in special circumstances of excellence and nicety. The legal principles were overshadowed. Explained by their lordships in so and so. In the same judgment, their lordships made so and so observation. It is submitted, claims fall in 3 heads. Justification has been explained. Settlement proceeded on certain assumptions. Those assumptions turned out to be incorrect. And the debts which are finally adjudicated turned out to be so and so. The justness of the settlement was based on the assumption of truth by this court. It is submitted, basic assumption being incorrect. The settled amount requires to be suitably enhanced. So it doesn't tell me on what legal principle the government of India is saying that this settlement amount has to be enhanced. When in my counter I say a court cannot. This is a settlement of suit. There's a suit on the original side and the court of civil procedure.
So the attorney will explain how.
I'm only saying today, I don't know what case I have to answer.
In a suit.
If he has something in writing, I need to take instructions.
Let us see, let him begin. When a
I only want you to
suit to be, in a suit to be tried, where it is settled beforehand on certain terms,
Yes.
on what principles that settlement can be opened, keeping in mind the two judgments. We'll have to keep in
I'm
mind
sorry,
the
but
two
I
judgments.
go one step further. Let me assume my learned friend can persuade your lordship that the settlement is wrongly entered. Let me assume. Then the settlement has to go.
We've taken note of that fact.
And have they made
But
up?
that's not his argument. See, therefore I put
That's
this
my
back.
problem.
His argument is, I'm
court can decide
asking,
the settlement.
I'm not asking for reopening of the settlement, but I will show jurisprudence to say that even where such a claim is settled, without opening the settlement, the opposite party can be burdened with some additional amount.
And that
So what-
jurisprudence, I have, I'm purely on the procedure of today. I don't know what that jurisprudence is. I wish it was in a note, a submission, a writing.
You will,
so
you
that
will
we
have the, as we will have, you will have the benefit of hearing the attorney how he brings the
Very. That's my thing.
I would have definitely done that, but what took me a little time was to scan the mass of documents to find out how do we really navigate in a case like this. And, in order to pursue a lawsuit, to simply say, look, at the curative petition has placed certain facts. Let me confine myself at a threshold to those facts. If those facts were good enough to pursue this court, we should notice the curative petition for a further consideration. And on a further consideration, those facts, if this court were to reach an immediate conclusion, yes, we will get into the merits of the matter as far as the finality of the settlement is concerned. And if those facts are good enough and persuasive enough to have, or to repeat what I said, to have the settlement amended as far as the quantum is concerned. Because the question of settlement, its need, relevance, and expedition, etc., have been gone through both the judgments, having regard to the enormity of the tragedy in this case. And therefore, notwithstanding that, when claimants had a reason to tell the court repeatedly that this case does not admit of those usual principles of a civil procedure court or even settled principles of tort, look into the court, you need to draw a different kind of a map altogether. Repeated attempts are being made. So in that context, if the minimal facts which have been placed in the curative petition were good enough to request the court to go further into the matter, then I would have done my job. So if there are objections to the document placed on record, I'll certainly look into some of them. But I want to say that the interveners, you have kindly come to the order, last order only the document compilation, the 11th of October 2022.
Yes.
Both the interveners are originally petitioners in many of these proceedings.
Maybe.
And they've been pleaded as petitioners. I read Your Lordship's directions are in the conspectus of the aforesaid. We issue the following directions. The government would represent the claim of the persons who suffer, and thus a joint comparison be required to be prepared with the office of the Attorney General and the respondent, which would be a comparison alone to be referred to in the proceedings. Insofar as the applications associations are concerned, we do not give any liberty to file any pleadings, but at the relevant stage, we will see to what extent assistance will be given by the council. We do not foreclose their rights to be heard by us at our discretion. Then, in conclusion, at the request of the Attorney General, some documents are permitted to be placed on record, limited to updating the position at ground level. There are two classes of documents which I received. One is the document to the process of the Welfare Commissioner, which updates and, in fact, confirms what has been stated in the curative petition. In the second set of documents, which throw light on what happened post 1991, the review judgment in relation to the position of UCC and what happened elsewhere in US and how certain transmutations have taken place. And also in regard to the documents which are placed by the interveners and the petitioners along as soon as the curative petitions are filed. We are part of the record before lawsuits began to hear the matter. So I looked
When
at
the
some of the documents.
interventions have not been
At no
allowed, when
point
the
of
petition
time.
of documents filed by them being part
In
of the
2011, they were placed on record. I did not find any so far, any objection raised to the placing of the document. Probably occasion did not arise. Let me look at it very broadly. Let me, because we are in a case where many of these issues will be contentious. But regardless of the contention, for a very good reason, let me say. If the court were to say, yes, let us look at the substance of the matter. If any of these documents will throw considerable light on which way the court will proceed to hear this matter, I would only urge the doctors to let the document be placed on record, regardless of any objections. And objections can be, how did they get these documents? What kind of source?
No.
Are they legitimate? I can understand all that.
That's not
So I would urge the doctors to probably not to say, so the documents being looked at this point of time.
No, first you'll have to lay down.
You lost
What-
ultimately reject them.
No, it can't be reverse way. No, that's not something permissible. That you will first read them out and then you may reject them. No.
You know, it will be like a case like this, perhaps
No,
I
no,
would
Mr. Attorney,
probably.
I'm sorry. I'm
Some of
sorry.
the documents were very, very
Sorry.
important
Can't,
dimensions.
we will not permit it to go on
There are
like
two
this.
classes.
You cannot permit it to go like this.
Let me try to.
You will have to first canvass your case as to what is broadly the case. Then we'll see what extent we are willing to examine it and whether we should at all permit some document to examine within the niceties of those pleas.
Let me put it like I quite see that. Because after all, the interest of the Union of India in a very extraordinary case like this, in a curative state, is that I don't want to get locked into a debate where some documents, even remotely relevant, indirectly relevant, I get locked into that. I would like to probably urge the court to get along with this matter, maintainability curative petition, and what grounds with the curative petition is stated, and what official documents are available to throw light on the case. And thereafter, if I'm able to still say at that point of time, if the documents can still be looked into, I don't want to get to that right away.
That's why, Attorney, we did not reject it at the threshold. What we are saying, you begin with your case minus these documents. We'll see how it goes.
Yeah, I quite see that. I think it's important to the purpose of
Tony,
both parties. Your Lord.
Can you just, we all know the parameters, Pura's case, the parameters of curative. Can you crystallize what are your arguments? What are the grounds on which you are raising this? Exactly what is the ground 1, 2, 3, 4?
Right.
And one, the documents which were already on record.
Right.
The documents which were not on record. There will be obviously data sector. There may be huge dispute as to the figures itself. Because what has been collected, not collected, causation, cause of death, etc., is very complicated. It's not so simple. Even medical science causation is not so simple.
And we are not.
And if we open up that, it will be
No,
firstly a full-fledged trial.
I don't
We are
think.
not analyzing trying a
You
suit.
can't.
We
I
are not
don't
trying
think I'm going.
no, I'm saying we are not trying an original suit, which must be understood.
No, I don't.
In a suit filed before the trial court, a settlement has arrived at here. Therefore, we are saying how, in what manner do you seek to open that settlement, and whether by saying that we are not opening the settlement but adding to the settlement, can it take place? Because you're not opening the settlement. So can you add to the settlement one way or the other? Let's put the reverse way. Suppose some facts would have arisen, which would have shown that actually the scenario was less horrific than it was made out to be. Okay. Could the other side have come and said, look, this is an excess amount I've paid. I want some money back. Could we have permitted that?
I would.
See, शुरू तो करें ना, शुरू setting out the contours of it. Yeah.
So the skeletal list of goods, we thought good
Yeah.
enough for the day to open up.
I'm sorry, but there are facts stated in this based on documents which are not admitted as yet.
Anyway, you will have your.
You will have your chance. We'll
There are only dates.
that issue, Mr. Salve, we already flagged in the.
No, I'm sorry, Manoj. There is a item saying meetings were held and correspondence between so and so scheme of the.
Anyway, when I,
We are
when I
going to read, we are only looking to the facts. We are not looking to the
No,
documents.
those facts are based on documents which are now being introduced.
We'll deal with it. Let us begin, otherwise we'll not end.
and this, And I've also had a very brief note of my argument. This will be supplemented later by a detailed note. I have both of them ready with me.
Yes.
So let me take a lot of the list of dates to have a broad overview of the matter. 1963 to 1970, Union Carbide Corporation sanctioned Carnegie Mellon Institute to conduct a toxic study of metal isocyanate, the findings of which were thought highly toxic with purulent skin penetration. It presents a definite hazard to life by inhalation. Then 16th of 1974, Union Carbide India conducted an internal study in the safety of MIC. In the study, it was found inter alia the highest rating of hazard for the internal pigment system, and the stringent precautions were taken to avoid any sort of human contact. It recognized that the poison made the residues likely in spite of prompt treatment from its source. The document was obtained through discovery process in so-and-so, Solver was Union Carbide Corporation, and in the U.S. District Court of Southern District of India. Then 2/12/1984 to so-and-so. On the intervening night of 2nd, 3rd December, a lethal gas stood than the Union Carbide leaked into the atmosphere, causing large number of deaths and serious injuries to a large number of people. At that time, Union Carbide Corporation owned 50.9% of the Union Carbide India Limited. 20th of February, Union of India enacted the Bhopal Gas Leak Disaster Act and changed the Bhopal Gas Disaster Registration and Procedure Scheme for registration, processing, determination, and compensation to each claim the appeal opinion arising therefrom. The Act authorized the Government of India as parent patriot to represent the victims and pursue their compensation effectively and equitably. Then meeting were held and correspondence exchanged between so-and-so, and persons from the Ministry of Chemicals and Fertilizers were in the scheme of the negotiated settlement to discuss based on the multi-tiered injuries. These documents marked top secret for review on filing RTIs. Then 8th of April, Union of India instituted action on behalf of the victims against UCC in United States District Court Southern District of New York for award of compensation for the damage caused by the disaster. Then 12th of May, 86, Judge Keenan, United States District Court of Southern District of New York dismissed the consolidated action instituted by Union of India and individual claims on the ground of foreign non-convenience in favor of the Indian foreign. 86, Union of India filed original civil suit in the Court of District at Bhopal against UCC, seeking compensation on US $3 billion. 13th of November, the Court of District Judge Bhopal passed an order in the original civil suit directing UCC to make an unencumbered assets of a fair market value of $3 billion to meet the decree passed by the court. On 17th of December, the Court of District of Bhopal as an interim order directing UCC to deposit rupees 350 crores for payment of substantial interim compensation and welfare measures for gas victims. Then 4th of April 1987, the Madhya Pradesh High Court at Jabalpur passed an order in civil revision by filed by UCC against the order dated 17th of December, whereby the quantum of interim compensation paid by UCC reduced to
Just one second.
240
Some,
crores.
some date may be wrong, I think. This first order of District Judge Bhopal is 17 December.
That's right.
Then you are saying
But
Madhya
wait,
Pradesh High Court at Jabalpur passed an order in civil revision against order of 17 December On 4th April, it can't be.
Must be 88.
88, I will 88. That is 88?
Is it 1988?
It's 1980. It's not, that's a moment. 80.
88, okay.
Then 88 special petitions are filed by both Union of India as well as UCC. So. Then 14th of today, Supreme Court in civil appeal passed a settlement order directing UCC to pay a sum of rupees US for 70 million to Union of India as full settlement of the claimant rights and liability that has been of MIC gas leak is called a settlement order. Then UCC is also deposited sum on the Union of India. Then Reserve Bank of India issued a letter indicating the procedure for the operations to account where the US dollars were converted to Indian rupees only when the same was required for disbursement. But that the loss in account of an exchange rate difference was borne by the Union of India. Then 14th of May 1989, Supreme Court in Civil Appeal number 7, SLP number 7, passed an order enumerating the reason and the basis that persevered the court to pass a settlement order for US for 70 million. The court considered the following estimates while arriving at the settlement amount. Let us look at the number of debt. Debt, assumed case of 3,000, amount allocated 70 crores, range of compensation to be paid is 1 lakh to 3 lakhs. So permanent disability is 30,000, temporary disability 20,000, at most severe case of 2,000, minor injury is 5,000. So that's how the figures are reckoned for the purpose of distribution of this compensation. Then 22nd of October, Supreme Court with a judgment dated so-and-so, report on so-and-so, upheld the constitutional validity of the Bhopal Gas Leak Disaster Processing Train Act 1985. 1990, Union of India approved a 5-year action plan of the state government of Madhya Pradesh with a capital outlay of rupees 163.10 crores for the medical, economic, social, and environmental rehabilitation for the Bhopal gas victims. The outlay was subsequently revised upwards to rupees 258 crores. The aforesaid action plan was to be shared by the government of India and the state government of Madhya Pradesh in the ratio of 75-25 and implemented by the state government of Madhya Pradesh from 1990 to August 1999. The 3rd of October 1991, Supreme Court dismissed the review petition filed against the orders dated 14th of February 89 and so on, and upheld the settlement orders. 13th of April 1992, the government of India laid on guidelines for determination of the compensation according to the directions of the Honorable Court with the order dated 14/5/1989. Then again, the government of India amended the guidelines for determination of the compensation and raised the compensation of death from 1.3 lakh to 1 to 5 lakh, 1 to 3 lakh to 1 to 5 lakh. The next, 29th of September, while not providing any documents on the safety or toxicity of MIC to the government of India, UCC submitted the carnelian toxic study of MIC to the Environmental Protection Agency in the US for statutory purpose, claiming that the document was confidential and the UCC retained publication rights of the report. Then October 92, Office of Welfare Commissioner Bhopal was established in the process of disbursement of the compensation initiated. 1994, UCC, after the review judgment, UCC sold the entire 50.9% Union Carbide India Limited, the McLeod Russell India Limited, Calcutta, a part of the Williamson Merger and Maker and Company Limited Group. UCIL was renamed as Everyday Industries India Limited. The new company had 2 divisions, the bulk tea division and managed the tea estate, the McLeod Russell, and the battery division, which marketed the Everyday batteries and flashlights. As part of this transaction, EIIL became the lessor of the property and assumed full responsibility for the environmental cleanup of the site. In 1998, the government of Madhya Pradesh revoked EIL's lease of the property and took responsibility for the property on as-is basis. And 1st of April 1996, McLeod Russell India Limited merged with Messrs. Everyday Industries India Limited with a Calcutta High Court order 16/6/1997 sanctioned the scheme of merger. Then 1998, Everyday Company India Private Limited incorporated. The 19th of July 2000, Everyday Company India Private Limited changed its name to Everyday Company India Limited. Then 2000, I'll come back to these transactions a little later to show the corporate, gains. Then 2000, Bhopal Memorial Hospital Research Center was set up by Bhopal Memorial Hospital in accordance with the order of the Supreme Court to provide free treatment to the victims of Bhopal gas leak tragedy. Then 2001, Union Carbide Corporation became a wholly owned subsidiary of the Dow Chemical Company. 1907-2004, Supreme Court with the order date in IA number 46 and 47 2004 directed the Welfare Commission to disburse the balance amount of approximately rupees 1,500 crore that had accumulated to the Reserve Bank of India on account of accrued interest and exchange rate variations on pro rata basis at the claimants whose cases had been settled. Then 1/4/2004, Bharti Division responded was demerged in favor of Everyday Company India Limited. Then 14/2005, Everyday Company India Limited changed its name to MacLeod Russell India Limited under a fresh certificate of incorporation. 4th of February, May 2007, Supreme Court dismissed IA number so and so and civil appeals number so that were filed to re-examine the inadequacy of Bhopal gas settlement. June 2008, 40 metric tons of line sludge was disposed of in the treatment, storage and disposal facility at the Vikram near Indore. Then 7/6/2010, the trial court in Bhopal with a judgment in order convicted the accused persons in section 304A Indian Penal Code and recorded categorical findings against the accused person. However, a mild sentence was imposed on the accused person. In 2010, Union of India took a comprehensive review of all the issues pertaining to the Bhopal gas leak tragedy. Accordingly, the central government, the state government of Madhya Pradesh, approved a sanction of rupees 72.75 crore to be shared in the ratio of 75:1 by implementing the new action plan 2010 for various rehabilitation measures to be taken for Bhopal gas victims. Central government allowed an amount of rupees 740.28 crores to be disbursed as a gratia to Bhopal gas victims under the categories of death, permanent disability, injury of utmost severity, and temporary disability cases. Two additional categories of cancer and total renal failure cases were also added for ex gratia payment in view of the increasing number of such cases. Compensation was as follows: death 10 lakhs, permanent disability 5 lakhs, cancer cases 2 lakhs, total renal failure 2 lakhs, temporary disability 1 lakh, less already received. In 2010, Government of India took over the BMHRC hospital and the BMS test was dissolved after the directive of the Supreme Court. Then 11th of October 2010, Indian Council of Medical Research was established with the mandate of conducting research in the field of environment health, including the research on the health issues of Bhopal gas tragedy victims. In December, Union of India filed the present curative petition before the Supreme Court claiming enhanced compensation in the response. Supreme Court issued notice and directors seemed to be heard in open court. Then 11th of May 2011, Supreme Court dismissed the curative petition in criminal appeal number so and so, and that's a slightly different issue. Then 11th of December 2015, Dow and EI DuPont, the Nomos and company, merged to form Dow DuPont with equal shareholding. Then 2019, Dow DuPont demerged into 3 separate entities called so and so, so and so. The spin-off was completed in April 1, 2019. At this time, Dow Incorporated became an independent, publicly traded company and the direct parent company, Dow Chemical Company. So these are broadly the set of facts which give an overview of the post-1994 two set of transactions. One, what happened to the compensation amount, how it was dispersed, and the need arose for the government of India to have a relook at the entire issue. And on the other hand, the transaction post-1991 between UCC and the series of internal corporate restructuring, including what happened in US. Both of them are connected in a manner of speaking. For I'll be admitted to be able to tell you a lot of why, notwithstanding all these developments as regard the corporate restructure, if at the first point of time, if UCC had told before the US courts that on grounds of forum non-convenience, the Indian courts will have a say in the matter, and the Indian courts will cover the jurisdiction. And the settlement of the parts of the jurisdiction issue, you cannot, on any volitional act of yours, for any reason whatsoever, resile yourself or to be relieved from the jurisdiction as your liability. If a liability and jurisdiction coexist, then the court will be free to examine further. As suppose 1991, on the basis of the liberty given by this court in the review judgment to examine the case on a research conducted by ICMR and so on and so forth, and then the process adopted by the Welfare Commissioner, that is the increasing number of deaths, the increase in the number of other categories of claims, then where do we go further? That's a question to be answered. So let me take a lot of brief notes and try to flag how probably there is a way of looking at it.
According to you, in the October 91 judgment of the review, there is a liberty given to the union.
I'll be able to show those passages.
Which paragraphs?
I'll just let me take the lodges on what I thought would be one way of looking at the whole issue. I know there are certain gray areas where the court may be called upon to fill those gray areas and gaps because we have absolutely no precedent where a mass tort litigation. I also place on record some compilation, but the US Mass Tort Group has considered a whole lot of settlements in the US courts and Alcoa's case. And where the settlement allowed a reopening clause and where it did not. And look at those categories of cases. And concerns are being expressed by academic writers. And look at the absence of a broad framework of law, which may deal with some of those, gray areas, liability, jurisdiction, conflict of laws questions, etc., can be addressed. So I'll take out all this very later point of time. So if this is a broad word of arguments, would be good enough. And then I have to take a lot in the review judgment and settlement judgment and see where probably how we can proceed. May I read this brief note? The curative petition is maintainable, both within the scope of the judgment titled so and so, and on necessary additions to be stated as to encompass cases of instant nature. It effectively addresses the lingering gap in doing complete justice to the Bhopal Gas victims, which has remained despite several attempts. Seen in the light of concerns expressed regarding the need for doing complete justice while affirming the settlement, neither the settlement judgment nor the review judgment can be seen as the last say and shall not come in the way of the adjudication of the curative petition. The intervening events in development between the review judgment and the filing of the curative petition and subsequent thereto are relevant factors persuasive enough for the honorable court to engage in the adjudication of the curative process for doing complete justice. For the reasons set out both in the settlement judgment and the review judgment and other facts and circumstances of this case, the continuing engagement of this court in monitoring the due enforcement of the settlement, the adequate availability of medical facilities, and the need for engagement in medical research, etc. Notice in 2012 AKCB 326, the review process will be seen not as having come to a termination, and the curative adjudication deserves to be treated as a continuation of the review process and not as a standalone procedure. This honorable court has always endorsed the importance of reviewing his own judgments in the public good. Post the judgment titled so and so, in addition to the grounds of public good and justice, the curative doctrine has added an important chapter on post-review adjudication. On a reading of all the principles that can be gathered from the judgment of the honorable court, it can be stated that the curative petition will be considered as the most appropriate source of doing complete justice. UCC is in breach of its twin obligation, namely the obligation to observe its duty of care and the obligation to do rectificatory justice by payment of relevant compensation. As long as the relevant and adequate compensation is not finally determined and paid, the obligation to make good the compensation will be treated as an undischarged obligation. For the purpose of securing due discharge of the obligation, the principles of restitution, tracing, and disgorgement of benefit and any other equitable principle of justice can be suitably fashioned and applied having regard to the special and unique features of this case. By reason of application of the principle, the respondents howsoever connected, should be held liable. The conventional approach of looking at connected corporate entities as distinct legal entities, either for determination of liability or exclusion thereof, will be singularly unjust and in infringement of the gas affected persons' right to life under Article 21 of the Constitution and their right of access to justice. The Bhopal Gas Disaster Act 1985 is reserved to be construed as a state intervention in the safeguarding of Article 21 rights of the victim must be read as expansively as possible to be in promotion of the rights of the gas affected people. The principle of power coupled with a duty will be read into this law, and the Union of India can both act suo motu as well as be compelled to act in the interest of justice. See so and so, so and so. Then none of the orders of judgment of the Honorable Court reported in 2007 9 SCC and 2011 so and so can operate either as res judicata or otherwise as a bar to the effective disposal of the curative proceedings. Sufficient facts and materials have been placed on record, which warrant reconsideration on the basis of the criteria adopted for payment of compensation to different categories of gas leak victims and also the quantum of compensation. On the application of well-set principles, namely mistake or fraud for reopening a settlement and for effecting amendments thereto, the settlement in question is liable to be reviewed. The effect and impact of gas leak has manifested over a period of time. Neither the figures relating to the number of deaths nor the nature of the medical disabilities and ailments have remained static. Considerable opinions exist on the continuing nature of ailments and impacts. The instance case deserves to be treated as an extraordinary instance of continuing wrong, and in which case the settlement judgment cannot be treated as a bar, nor the intervening period between the settlement and the curative petition can be treated as a matter of delay. The settlement has been arrived at in the course of interlocutory proceedings, though the question of liability, whether strict or absolute, has not been determined in the course of a trial. The settlement procedure virtually closed all the further proceedings. The gain on the one hand by way of expedient settlement, and the loss on the other hand by reason of absence of concluded trial determination, have to be seen as necessary factors. UCC, after having objected to the jurisdiction of the US courts, could not have taken a different stand before the Indian courts, and also canvassed the settlement has no bearing or relevance in the question of jurisdiction. It must be taken as a settlement in a manner of speaking, settles the question of jurisdiction against UCC. Consequently, it will be taken that implicit in the settlement is the acceptance of liability for the MIC gas leaks and the obligation to bear the damages through compensation. Since the settlement has to be seen only as a partial measure of compensation, affecting full measure of compensation will require UCC to continue to discharge its obligation even after the settlement judgment, regardless of any changes or alteration in respect of its status, either in connection with UCIL or any other entity happening after the review judgment. Non-discharge of the obligation to effect full measure of compensation has resulted in saving the expense. This saving measure will also be considered as a gain. These are debates in the subject of unjust enrichment and restitution deal with varied claims of restitution. In this context, the doctrine of tracing to reach at a value that has been saved has been invoked. Having regard to the arrangement that UCC have made post-settlement and avoided discharging full measure of settlement, which subject to the doctrine of tracing can be invoked with an appropriate favor for the purpose of securing discharge a full measure of compensation for UCC and all or any of its connected entities.
What is it talking about? Paragraph 10.
Paragraph 10. Paragraph 10.
Yes.
Here the documents come in sufficient and materials are in place.
Page that is when we are applying on to it.
Okay. Yes, please.
I just wanted to say one thing, because, and I must say, my instructions are to appear, I'm an American chap. Instructions are to appear in proceedings arising out of the suit. Now, I noticed in the paper just handed over, there are claims for relief and rehabilitation, including disposal of toxic waste, none of which are in the plaint. Because plaint arose out of the act suing on behalf of the people who were
We've
suffering.
taken note of it.
I am not, my presence here should not be taken as UCC acceding to the jurisdiction of Indian courts on any of the other issues.
The suit has come here. You said these proceedings arise out of the suit, Mr. Salve.
No, there are matters here which are not in the suit.
Suppose now, to test this, suppose the suit was amended, then what will happen?
I'll tell you why. The suit was filed under the Bhopal Act as on behalf. The suit was filed under the Bhopal Act, expressly stating, so the plaintiff is very important, that this is the death and injury claim. Now, if that suit is being amended, and that's what the suit which was filed in the US, which got transferred here, to which we acceded, UCC acceded to jurisdiction. If the remit of that suit is now saying, in 20 years after the accident, the government of India has spent material on removing toxic waste. That's not a suit for death and injury caused in 1984. If that amendment is allowed, would UCC agree to jurisdiction, not agree? They need not agree, but it may not have any implications here. The Indian court may say, sorry, I'm holding you liable. And then don't keep any cards up my sleeve. Because if tomorrow a judgment is passed and it is put in enforcement, and UCC in the US court wants to resist enforcement, my presence here should not be taken that we have acceded to anything. Saying you participated there in the hearing, you took your chance in the Supreme Court, you lost, now you can't resist the decree.
You're looking far too ahead.
But I have been instructed by clients to make that clear because there are very far-reaching implications. So that's why I wanted to state it.
Okay.
I'm not stating it out of any arrogance or anything. The court must fairly know what our position.
Yes.
I exactly tried to address that question. So there are more than one point of view on this issue. And the more you get into the conflict of law ticket, there are so many rules which the highways and the bylanes which courts have looked at various principles to address this question. Maybe the course of argument, we need to look at some of them. I thought
See, one thing we were just discussing, when you do the calculations, say for in your earlier note of 2010, where you decided to
yes.
revise some expenditure payments.
Therefore, let me take a lot
2010 is more than 25 years after the incident. Correct. What is the causation of a medical problem with this 25 years hence? Just as a
I understand. I asked.
Also a problem.
I myself asked.
There can be many natural causations which may arise by lapse of so many years of time.
For instance, in the asbestos related cases, one of the cases was you have a series of employers where you get employed. Exposure to asbestos in the environment. So the courts try to look at this question by saying, what's the degree of exposure to environment? What's the degree of exposure to a employment related situation? If there could be even a marginal degree of difference between an exposure in the workplace, then the court will lean in favor of compensation. Therefore, these are principles with the
whole problem is this would be dependent on evidence.
No, I understand. That's why
That's the problem. If evidence was placed before a trial court, you may be able to show that look, even 20 years hence, so and so has a causation for it.
Right.
It may have a part causation for it.
Right.
Or it may not have a causation.
Correct.
We are not dealing with any evidence. We have no evidence. We have the suit never went to trial.
That's a matter which, of course, will be a matter of some concern and anxiety for the court before it can proceed to say some final word on that. I've also thought about that. But since the Act virtually replaced, and your lordships giving a stamp of approval and the settlement, and said the parents' patria in the Union of India will represent the case of the victims, even though the question of oppositional opportunity was raised by Justice Mukherjee, the challenge issue. So these are dimensions virtually brought in a process of the welfare commissioner acting as a court, trying the nature of claims and the categorization of the claims. The Act therefore endorsed it. And the Act has been endorsed by this court. The process adopted as statutory framework for all practical purposes must be treated as a valid process. And we be close enough for the purpose of looking at not only the enforcement of the settlement, but also if the need arises for looking at the review of the settlement itself. Whether there is an agreement on that question or not, there'll be little more persuasion arguments will be required to do that. But I thought that's one way of looking at it. Of course, there's no trial. Nobody can ignore that. But the Act replaced every process of it. And the Act has become the field where everything will take place. So the Welfare Commissioner went ahead in looking at these claims. And the figures changed over a period of time. And they looked at those criteria which have been laid on under the scheme, not any arbitrary criteria. So under the scheme, uniformly for all people. They've also tried to address this question, what will be whether if there are multiple exposure, multiple reasons for a certain kind of ailment, the medical disabilities, which one I would choose as the most proximate reason. So you've also tried to examine all that. So there could be some areas where the figures may be disputed and so on and so forth. So after having a series of conferences with the Welfare Commissioner and the authority, I also have some questions in my mind. How do we really address some of them? It is not as if it's a closed case where things can be written clean slate. I'm not saying that. But regardless of all that, because I think in a case like this, these dimension aspects are bound to be there. They're bound to be there. You just can't close your eyes to all that. Therefore, you post-2010 Welfare Commissioner has arrived at certain figures, which are vastly different from the figures assumed by the court. when the settlement judgment was delivered. Then whether these figures, which are a due process of law determinations, would not qualify as grounds and reasons as set out in the curative petition for the court to look at.
How would the court assume any figures? The union must have given those figures.
Yes, sir, we have the curative petition.
No, not curative. At the time when the settlement was accepted.
No,
And then the
settlement,
figures must have been given by the union.
That's the only question. According to the settlement, the figures were A, but the real figure that emerged after a due process of law is B. Therefore, we're looking at whether there's due process of law.
84 to 89, you did not have the correct figure. And you entered into a settlement.
So the entire assumption of the review settlement was in certain figures which were not on the basis of any final concluded examination. Therefore, a number of deaths from 3,000, ultimately more than 5,000 odd deaths. And as confirmed with the Welfare Commission. Even though there is an area where the interveners and the petitioners say the number of deaths is 22,000, and we stand by something lesser than that. So I'm still trying to find out whether there is a area where there is a conflict or disagreement.
When
I don't presently come to that.
welfare commissioner determined these figures,
Yes, yes.
whether company was heard. The company was heard when welfare commissioner determined these revised figures.
The Supreme Court endorsed the scheme under the Act.
Correct. And
So
under the
once the-
scheme he was acting.
Under the scheme, therefore, their presence was probably not required at all. And if that was required, they could have asked for it. I mean, no determination with the welfare commissioner court to go behind our back. Because those
I was
demands,
saying they should have asked for it. The issue is if the welfare commissioner is acting under a scheme of the Supreme Court, then on one hand you want to open it, on the other hand you want to say that it's for them to ask. There's nothing for them to ask because in their perception, whatever their liability was, more or less, was reconciled to a figure which they paid.
Right.
If they had not paid it, of course, issues would have arisen.
these figures,
Therefore, when I read through the list also, what corporate shenanigans went through it in terms of how the company was, from one entity went to another entity, from another to
I'll completely clear. I am not on that for the time.
completely irrelevant.
I'm not on the time frame being. I'm not on that.
Because that's only fixation of liability. How to fix it? Those principles come in if something is quantified against them.
Absolutely.
They don't pay, then whether by alleged subterfuge they can avoid the liability is where we go behind and see how the corporate restructuring has taken place.
But in
That-
2006,
in my understanding.
why not just not ask a question, when did you first discover that the figures were? In October 2006, the Union of India files an affidavit in this one. And in that affidavit, they say that in any case, the validity of the settlement by no stretch of interpretation can be questioned in 2006. As each and every claimant has got compensation as per law and is entitlement. And the amount of settlement has finally been found to be in surplus or excess of the actual requirement. And the leftover amount in Reserve Bank is 1,500 crores, which was directed to be disbursed pro rata. This is in 2006. After the curative, on
We did a
2nd
claim in 2011.
on 2nd November 2011, the welfare commissioner files yet another affidavit saying all claimants have been paid compensation twice over and there is no.
So that's in terms of the original settlement corpus, not in terms of the increase in the number of deaths and the increase in the number of other categories of age.
Claimants are paid.
The present claimant. Let's be very clear about it. The review judgment says talks about the present claimants.
Is it your case that when they say claimants have been paid, some of them and number of them have not been paid at all at that stage?
No, that's not the case. The question is, if the number of deaths assumed was 3,000, it is now 5,749 according to the Welfare Commission determination. And I said, if
All
that
of the-
number has gone up.
So all of them have been paid according to whatever formula.
So that's why
Then why is money lying? Things are wholly contradictory. Is it that we don't think government will be pocketing money for its own benefit?
that's not the
Correct.
what the government.
So to the last penny, they would like to disburse the amount given by them, and in terms of as a welfare state, as envisaged in the latter judgment to which the
There are two
government
aspects. Let me-
court is given an imprimatur, they would have put
There are
in
two
funds.
But honestly, the answer should be, there is not one single claim pending for the welfare commission.
The question is not whether the claim is pending. The question is the quantum of compensation. The quantum of compensation was fixed at 1 to 3 lakhs. Nobody got beyond 1 to 5 lakhs. The government of India extra compensated something else. How do you reckon that in the account? Therefore, we are talking about it.
Mr.
It is
Attorney,
liability, an obligation.
No, let's be very clear. The claims have arisen because of the 2010 decision to enhance the compensation in case of death to 10 lakhs. Is that the reason or some other reason? Because then you also bifurcated the amounts as you're given in the table. Is that the reason? What is the reason? Because did the shortfall take place because the compensation was increased
Yeah.
from
There are
3
two.
lakhs?
One is a number.
Number we
Number.
understood. One
So
number.
the number.
Here the causation.
And the quantum per person, for instance, for death, you're liable to pay 1 to 3 lakhs. But the number increases, right? And the quantum also, we have a problem. With the quantum of compensation also, there is a question. If somebody was entitled to get, you look at the value of life in India. You're looking at 1 lakh to 1.5 lakhs. And the government out of here, in account of the desperation of the gas victims, after so many years said, look, we must go to the
After
rescue
25
and
years,
encourage your payment
no,
to
but it took you 25 years to realize that the compensation paid fixed earlier was wrong.
That's why these two reasons, one is the number. Number
I
is
just-
important factor.
Just as a matter
Number
of
is
fact,
very
I just went through
Yeah.
the income tax slabs for 2000. Wow,
My lordship's read, yeah.
I just tell you, the income tax slab as far as 84-85 is concerned, the exemption was 15,000. Below that, above that, everything was taxable. If you crossed 1 lakh, it was taxable at the rate of 60% plus 12.5% surcharge. That was the maximum tax slab. 1 lakh was the maximum limit. Now in 2010, the exemption was 1,50,000. And after 5 lakhs, it was the maximum. Forget about that. It doesn't matter. That doesn't matter.
See, value of money will have to be
Yeah.
seen
Well,
from
can you
perspective.
look at why the union is so concerned about saying, I want to present the curative petition. We are talking about a loss of life and loss of several precious aspects of life to a large number of people.
How much money would the government have put in?
I play that, what, we have a certain figure available. I'll take it on that. But in view of these questions,
Only one thing, as a matter of fact,
Your Lordship,
in 2010, you took a decision to pay 10 lakhs.
that's why we an ex gratia account.
Correct.
Ex gratia.
Was that amount paid by the government to each and every claimant was identified earlier?
That's right.
Everybody was paid 10 lakhs.
Yes, yes. I will give you all the data. It was a very depressing situation.
So, I'm still not able to. I don't know.
Can I do one thing?
How can money still lie? Which
Can
was
I
deposited by
do
the-
one? Can I do one? I have a certain set of figures of the data available. That is given some information. Can I probably put them in a perspective? Right?
Amount is balance.
Whoever wanted to be paid.
There is not a single claim pending is the
Yes, sir.
affidavit. And the RBI on 29th June 22 gave a letter saying amount now available for disbursement 50 crores 25 lakhs. Slide in the bank. 22 June.
Have you, because you had a liability in terms of welfare state emphasized by the court. Do I take it everybody has now been paid?
I take a loss.
Everybody has been paid in terms of 2010 decision, whether everybody has been paid.
Yes. What I
been
want
paid.
to say is how do we look at those figures? In what manner it was
You
done?
can't keep
And
looking at attorney at those
Correct.
figures. How to
I-
look
I
at
just-
those figures? How to look at 2010? How to look at 1984? How to look at this question? Let's not complicate the question.
No, I'm
which
not.
is there.
My question.
The question is very simple, and you have answered that everybody has been paid.
Right.
Now there's no liability pending. Then why is 50 crores lying?
Now
Who is the 50 crores meant for?
that will be explained in the note which I am placing.
Which is
Now-
this note now?
Now, you're not standing first.
Is it some other third note?
This is a note in support of the figures in the curative petition. In the curative petition, there are three claims. Claim 1, 2, and 3.
Yes.
Just kindly turn to the second page of this note. This gives the status of
All this will be. Some claims are not in the scope like environmental degradation. Vendors will now very open source.
Yes, so you can hide it. It's the
Way of responding if you know. This is very well like not much like the 3 case, but
Mr. Attorney, only one thing, you are given these figures. For example, debt figures, 3,000. This start second page of this note, you handed over. Second page, right? Now, actual number of cases were 5295. Correct?
later.
So we want to know whether you have paid all these 5,9 in all these cases, 5295 cases at the rate of 10 lakhs, you have paid to everybody.
Yes, sir. I'll show those details in our compilation.
So therefore, whatever amount you have specified here, according to you, and everybody has been claimed. Additional claimers were identified later on. Everybody has been paid.
Yes.
Is that correct?
Yes.
And look at it, look at the irony. 84 or 85 people would have died. At that time, you gave 1 to 3 lakhs to the immediately to the family members. After 25, 26 years, you enhance it to 10 lakhs. By the time one generation would have gone.
That's all the more a reason.
1 minute, please. That's the irony that you take 25, 26 years to decide what is the amount. And if you had to take that corrective action, you should have taken it. I could understand the curative was filed decided in 1991. Sorry, the review was decided in 1991. Review. I'm correcting myself. 1990 or that by that time you knew the figures. No. Death cases you knew the figures.
No. That's a problem. The welfare commissioner has to engage himself over a period of time to look at the number of deaths.
What can be done if for 25 years you can't come to the figures?
That's not a question of 25 years.
Sorry, it's a reflection on the government rather than anything.
Great respect, Lord. Great respect.
Of course.
The question of determining the number of deaths, is it merely a jugglery with figures? No, it has to go through a process. So the process went on. And within 19...
Process goes on. Attorney, please turn to your current note. Turn to the table, the first table which is there. Correct? Turn to the first table.
These are figures
Yes.
which have been stated in the curative petition.
Additional amounts required due to increased fatalities and injuries not taken into account. Correct? Now let's go category wise. In case of additional amount required to be paid for death is 53 crores. Correct? the amount required for permanent disability is minus 208 crores. The amount required for temporary disability is plus 77 crores. The amount for severe cases is minus 78 crores. I'm skipping the next for the time being. Loss of property minus 74 crores. Loss of livestock minus 49. Where is the difference coming? And now I'll flag it. The difference is coming in minor injury cases, where instead of original amount, you have increased it by 1,000 crores for minor injuries. If you want to distribute funds for certain reasons,
not on any ipsy dixie, on the basis of the process of the
No,
claim.
but then
the chart shows it.
Minor
No,
injuries.
these are two pages.
Minor injuries are after 25 years, certainly for minor injuries alone.
You have to pay
For
only
other
amount of
things, you find your funds
20,000.
are actually in excess.
No.
But for minor injuries, suddenly you say, I need 1,000 crores more for minor injuries.
Not that right.
This is what it means.
The question, let me
What is the definition of minor injury?
You would not just
What-
give me a little time.
What is the
to explain.
definition of minor
Let
injury?
me try to explain this. And these figures at pages 1 and 2
Yes.
are what is the figures derived upon by the settlement draft. These are those figures in 1991. Now, after 1991, when the process of review of the consideration of those claims, which were kept to be registered over a period of time, and the registration also came to a conclusion somewhere around 1996 or so, then the consideration took place around the 5-6 years. The review process came to an end of all this somewhere around 2005 or 2006. So by that time, we knew the exact number of deaths and the shifting of cases from
What I'm
minor
saying is
injuries
the
to
rarely
major
is-
injuries, permanent disability.
The rarely seriously affected, the loss of property, loss of livestock, are all where less has been spent than anticipated. But permanent disability is other. But suddenly for minor injury cases, you up the figure because you try to cover many more people. Like
Great
how
respect.
after 20
With
years,
great
minor
respect,
injuries have to
even
be
a
taken into account.
categorization. No, I wait.
I'm sorry, doesn't evoke confidence.
The question, why it all happened, how it all happened, there is enough explanations for that. There is nothing which has happened by any arbitrary criteria. The question of a minor injury becoming a permanent disability was, for instance, there are cases where said death is owing to MIC. The commission said no, it could be for other reasons. Therefore, claimants have been rejected. Therefore, if a shifting of one claim from one category to other category has been under the due process of the scheme endorsed by the honorable court. It is not.
One more problem.
Yeah.
Assuming everything in your favor, the curative is maintainable,
Yes.
we can entertain it. But again, all this becomes matter of evidence and matter of proof.
I will try to address that.
And that is curative,
I
we have
will
to do
try
this
to-
fact-finding exercise.
I will try to address that issue. Now, if your lordship.
You assume minor injury cases of 50,000. Now you are saying there's 5.25 lakh minor injury cases.
I'm sorry. Because we've been grappling with this for 10 years. The affidavit is filed by the union in 2011. The total figures are 574,376 in 2011, which is the same figure in the attorney's.
Yes.
It says all this has been done. Then it says we want to tell the Supreme Court that the government of group of youngsters said pay 10 lakhs. So 10 lakhs for death, 5 lakhs for permanent disability, 2 lakhs for cancer, renal failure, etc. Then 10,000 under death for awarded as injury, etc., etc. It is pertinent to the figures mentioned in para 9 may be varied. Group of ministers has recommended. In addition, 582 crores has been released, and all this is paid and done and dusted. Is the affidavit in 2011 for same number of figures? Post curative. Your lordship must see that.
Right.
Because that's an affidavit, it's a reply of 21st November filed by the Welfare Commission.
What I'm stating here is not in deviation from what we stated in the affidavit. Kindly turn to pages 4 and 4 onwards of this note. So what your lordship read in pages 1 and 2 was the position obtaining in 1991.
Was any claim laid towards relief and rehabilitation measures in the suit?
We don't just read these 2 pages, then some clarity.
We'll read. I'm just saying, you are trying
Kindly turn to
bring
page
in-
4. Page 4.
Please understand, you are trying to bring in claims here. Which were never part of the suit which was resolved. If you want to do some other claims in respect of claims, then you can't do it in a curative petition.
May I try to understand it like this?
In Charanlal Sahu,
I will
constitutional
read.
bench,
I
the
will
Attorney General made a statement. I'm sorry, Attorney General made a statement. We are not claiming anything towards this.
At that time, the attorney did not know 5,000 people have died.
No. I'm sorry.
The attorney did not.
The
Nobody
government
knew.
of
Nobody
India,
knew at that time.
the government of India would not seek any reimbursement on account of expenditure incurred so moto for relief and rehabilitation of the Bhopal Gas system, nor will the government or its instrumentality make any claim on its own arising from the disaster. Now, if the government has spent monies on curative work, that is money spent by the government, independent of this, can they bring an action against UCC, the separate matter?
I definitely answer.
No, the query was different. There was a claim made for payment of compensation out of death, disability, etc. In the original,
Yes.
no discussion about it. We are on this claim number 2 and 3 is 1743 on account of
Your Lordship
relief and
reading it.
rehabilitation.
Your Lordship reading it.
Claim number 2 and 3.
Page 3.
Whether these claims were made in the suit. Claims under these heads were made in the suit. That's what we are asking.
Claim on account of environmental degradation. These are fresh claims which you are seeking to make.
Claim 1 was certainly made. But claim 2 and 3, whether they were claims made under these heading in the suit. Claims 2 and 3.
Claims 2 and 3.
How can they, my question is, how can they arrive in a curative? If you want to claim some other amounts against Carbide on account of your better knowledge 25 or 30 years or 50 years hence, file the proceedings. You can't do it in a curative petition. Who stops you from?
I was saying is,
May I read Your Lordship's kind consideration? How did the review judgment look at it? And if the curative petition, if I am.
No, you may be right also. You can argue that. As a matter of fact, we want to have claims 2 and 3. Under these heads, there are claims in the original claim.
Right. But there are some parts of the judgment where these issues were flagged, but not necessarily addressed.
It is not,
I saw that.
Mr. Attorney, I'm not able to comprehend at all this aspect. This is a compromise in a suit. Let's not say, oh, this is a very unusual thing that has happened. These episodes have occurred all over the world periodically. Unfortunate times. Now, magnitudes have been, yes, many of them are magnitudes equivalent. See, in India, fortunately, we've been fortunate it is not arisen. One is not denying the magnitude, but something you have not claimed. Therefore, your best claim can be, well, how can there be a settlement of this amount? Because nothing was claimed on this account. If it is not claimed, it is not settled. Chapter is over, claim it. Therefore, I put a question, you claim it. If you claim it and you are entitled to claim it, and if you want to defend it, and they'll defend it in whatever proceedings arise. In a curative, how can you go into it? That's the whole issue. Claims 2 and 3 never forming subject matter of the suit. If in accordance with law you are entitled to claim it, please. We are not prohibiting you from claiming it, but we can't go into a curative in this.
Just
Multiplication of figures, what you think should be now, I want this also, I want that also. Maybe you are right, but there's a process by which you will have to claim it.
I tried to find out in the compilation. I could not locate claims.
Claim 2 and 3.
For that.
Let us say, if you move claim 2 and 3, what can you claim against them? According to you, I am taking your case at the best.
So, Donnie, just coming to your figures, right? Probably the figure at the table A is 675.96, which includes this figure of 99, which
955.
955 may be wrong because it doesn't tally. I don't know how you taken 955. Additional amount in crores you've taken. So 675.96 is one. If table number 1 or page number 2 of your table.
table number 1 is page 1.
Or
Page
page
2. Page 2.
I'm talking about this.
Of this third
Appendix
document, Appendix A.
Appendix A.
the Charan Lal's how judgment came. One of the challenges was in what capacity the government suing. The Attorney General made a statement saying we are not going to be pressing for any claims of recovery of what the government is paying. That's in 89. This is 86.
Let me look at the judgment. Let me tell you why it all happened. Look at it.
Why is another story?
Let us look at
Why, how,
Let us
whose
look at it.
wisdom,
Kindly-
whose
kindly
lack
let
of
us look at
wisdom
the
is
context and how certain submissions are made. So we are looking at a very extraordinary situation. Sorry to repeat that, because in this extraordinary situation, what could have been anticipated? The only concern at the review, at the settlement order was if that trial were to go on for long years, unending.
Correct, correct.
That could be avoided, and to
So
obviate
people,
that.
therefore, the persons who have suffered should get benefit at an early date. That is the philosophy of a settlement. Those monies were given have to be disbursed. Now, you made certain statements because to benefit the people who suffered in this. Now you say no, government is spending much more money on different aspects. They are, as tort fees are required to be parceled with those liabilities.
Yeah.
Claim it, it will be tried. How should in a curative parcel this on to them? Whether it is a claim of grief and rehabilitation, whether it's participation of environment degradation, all these you may not have a claim, we don't know. But you are wanting us to determine these claims in a curative petition dealing with the issue of claim satisfaction of the persons who had suffered various forms of injuries and ailments. How do you mix up all this? How do you do this?
Responsible. It needs to go through the review
government
and the initial settlement order. I'm not saying these questions are to be discussed like that. But how do we find an answer to this very vexing question? So at different points of time, the courts have looked at certain dimensions of the case. Certain dimensions of the case, and therefore we gave an answer. And stand was taken by the Union of India or with other parties. So on the basis of certain assumptions of facts. So therefore with the review.
Those assumptions,
Let me go to the review.
let us say you find no, those assumptions today don't hold, get them determined in proper proceedings. Please don't put this in a curative before us. Is all we are saying. If after 39 years you want to now sue them for something, please do it if you can. Please recover it if you can. Actually,
number one.
claims is like some fresh suit which you are seeking to file. Interested LIBOR rates, CPI to be applied. You are filing a claim, you file a suit then. File a suit for whatever you think is recoverable against them. After 39 years.
First,
Just one more thing. Just turn to your table once again. I don't know. Somebody has to apply, because here you say, as per the Supreme Court order, the total amount provided is
reading at which page?
page 2. Sorry,
Page 2.
the next
Appendix A.
appendix A, column number 2. The total amount provided as per the Supreme Court order was 725 crores.
Yes.
725 crores. Then we turn to the page 3. The total amount paid ex gratia in terms of based upon the Government of India decision dated 24/6/2010, GOMM recommendation dated 27/9/2010 is 740.28. There the gap is very little. It's not substantial, even if you go by your figures. And the figures get really, there's a change in figures largely on account of the fact of the minor injuries. Minor injuries figures going up from, it's virtually from 50,000 go to 5,27,000. And that makes a difference of 955, 1,000 crores virtually.
With these numbers,
So these are these figures. Then obviously there's something little odd. There is something difficult because the other numbers which have really is 1,000 crores with regard to the government of India expenditure and 315.70 crores on account of environmental damage. Somebody must have done some calculation. These figures will have to be all. How do we estimate?
these are only abstract.
So dehorse,
I've given only the abstract.
endeavoring to put it on dehorse the settlement. You feel you are entitled to number of amounts more. It either did not specifically get claimed in the suit or otherwise. Please file whatever you want to before whatever court you want. How can you do it in a curative petition? That's the question.
We'll also kindly turn to some of the observations in the review judgment. And
Tell us where it says
And,
that everything can be opened whenever you want. It is so, we'll see.
Not asking, not what is the definition of minor injury that is defined in an affidavit of October 2006. That whoever was present and filed a claim because of the trauma that they had to suffer because of the gas leak. It's in their affidavit. I'm not exaggerating.
That was defined as a minor injury.
Yes.
these are of course, under the scheme, there are certain.
And the government's words were, whoever was present and filed a claim was granted compensation on account of trauma that had to be gone through. And that the basis of mere presence.
What is the compensation amount, Vikram?
I'm sorry.
What is the compensation amount?
50,000.
What's that minor injury?
50,000.
20,000.
Ranges,
What
there's
then
a range.
becomes- Therefore, they say we have paid extra 600 crores. Now net present value applying live on.
That these are the points.
That's the security.
See, from 50,000 cases of people who may have suffered a trauma, you are, for which 100 crores was provided on 20,000 rupees, you said actually people who have suffered a trauma are 5,27,894.
That's
And therefore we spent 1,000 crores more.
right.
There are
And we had checked for the population of Bhopal at that time was around that thing, 12 million.
56 wards.
So everybody
But
suffered
the
trauma,
purpose
everybody
is
they've given a figure.
There are defined set of wards where the gas leak exposure were determined, and all these people within the 56 wards with a minor injuries category was to be
So if
redone.
you are saying trauma, we are not disputing. So you say that anybody who has been in this affected ward will be effectively treated as somebody who suffered a trauma because the gas leaks occurred there. Therefore, you give it to everybody. Nothing wrong with that. Question is, on this basis, can you open a settlement?
The number is a very important.
Number is because you
Number very
knew
important.
what populations were there. You chose and thought that you will give it to something more. Now, if you want to give it to everybody who has a trauma, salutary benefit.
No, we didn't choose. It's all in terms of the court saying you will go to process this claim under the scheme. The scheme was a well-defined procedure, and it was not an open-ended issue. Therefore, if the scheme allowed people to lodge claims and the commissioners to do their job in terms of the criteria, then unless somebody has to say, yes, all this is wrong.
No, it's not necessary to say it's wrong. Somebody has to say also it is right.
I'll tell you why it is right.
Without evidence, how can
I
it
shall
be
not
right or wrong?
Therefore, we are only.
You may be right, but how can it be decided?
Therefore,
In a curative, you want us to decide it. We are again and again repeating the same thing. In a curative, what you are saying is, this is being paid by us, ask them to pay this to us. This is what, beyond that, we can't go in curative because we are only dealing with the settlement. There is no trial here, there is no trial there, there is no trial anywhere else.
I quite see that. If the absence of a trial, that's why I said if
Just please
that
see.
trial was.
All the sympathy for all the people who have suffered. Cannot ask us to turn into such an ad hocism
Look at
on determination of amount because you say you are wiser today. That's what is happening.
It is I look at it like it's not logical person say that. And before I do that, can I read both the settlement order and the review judgment, whatever effect they have, bearing on what we are trying to report. So, we'll also kindly pick up volume 1 of the respondent's documents. Page 45, that's the first settlement order.
What do you want to read?
Agree. Please turn to page 41, which is the first order in February 14.
Just one clarification for, if you turn to your chart at page, sorry, I'm taking you back.
Page number.
If the figures interest.
Appendix A.
Appendix A. The amount which was initially provided was 725 crores. Is that correct? As per your chart itself? Then you have additional amount required to be paid. That's an extra amount, which is 675 crores. Is that correct? This is above. This will mean over and above 725 crores. Is that correct? Now, at page number 3, this figure of 740.28 crores under the heading 2, Roman 2, capital 2, ex gratia amount.
Yes.
This amount is the actual amount paid or is the additional amount paid?
Actual amount paid minus,
Not the additional amount paid or the actual amount paid?
minus the initial amount received plus this deducted, less amount. The amount was less.
No, so attorney, do you mean that you have paid 675.96 plus 740.28? Have you paid both?
Yes, yes, yes.
Is that your case?
Correct.
No, you have paid, therefore you have paid 675
In excess.
with 675 was paid initially. And thereafter, after 2010, it became 740.28. Or it was in addition to it.
This is in addition to that.
$75.96, the additional amount you pay. They paid 725 and paid 675.
Both.
Correct?
And
Are we understanding correct that 725 crores is what was envisaged and provided for? This amount you would have paid, but still somehow 50 crores is lying, which we do not know why it is lying. Then you have paid, according to you, additional amount because of the increase between somewhere increase,
Because of
somewhere
the
increase.
actual number of cases, there is an increase. The actual number of cases. The number of cases assumed is 3,000. Actual number of cases is 5295. Therefore, an additional amount required to be paid in the last
Without
column.
getting into detail, is all arising for whatever it's worth, account of minor injury. You know the figure, there are minor injuries otherwise. So you paid 725 crores you have in your hand to be paid. Correct?
Yes.
Apart from that, you say,
One second. The number of cases assumed in the first column is 2,05,000.
yes.
When the number of cases went up, which is there in the last but third
See,
column,
see.
5,74,000.
Because of this, you are required to pay 725 plus 675.
That's right.
Correct. This is what you say you are required
Correct.
to
correct.
And you have paid that amount.
That's right.
And you have paid that amount. Now, please be sure, have you paid that amount? Because otherwise the question will be posed to you, which we pose. Why is 50 crore lying with the RBI? If you have paid. Who have you not paid? And if you now turn, see, confusion. Now, when you come to claim 2, which prima facie is not, you said amount spent on account of rehabilitation, etc., is so much.
And then amount ex gratia is 740.
Ex gratia is 740. So 1743 is what you have claimed under a claim 2. Then there's a claim 3, where you say environment degradation.
You must clearly say whether you have paid 725 plus 675 plus 740.
Out of the 725 which they were supposed to pay initially, they have paid 740. This is what they want additional.
No. What they must say clearly, whether they have paid 725 plus 675 plus 740. Whether all three figures they have paid.
All the three figures, 740 is a part of the.
So our simple question is whether you have paid one figure of 725.
Plus 740.
No. Let us go by this. So 725 plus 675.96.
675 is required to be paid.
There is addition.
If you also give an increase in the number.
But you
By
did not
reason
pay
of
this.
increase in the number.
There's an increase in number. So 740.
Increase in the
Okay,
number.
let us begin first. You have paid
40.
You have paid 740.
740.
As against 725, you have paid
725 plus 740.
So that means that you have not paid any compensation to those persons who are identified subsequent to the compromise.
Not like that. 670 was required to be paid. Right. But that was on the assumption.
No,
the
but
average
there
amount-
you may not be right, because if you see the simple mathematics, if you see this 675 is in addition to 725. Just calculate it for yourself. Correct.
It because the difference in the number of.
So coming now to the state question.
Yes.
How much is the total amount you have paid on account of all these heads? Death, permanent liability, temporary liability, severe cases, minor injury, loss of property and livestock. How much is the total amount you have paid till today?
725 plus the ex gratia 740 which you made over.
Right.
This has been paid.
Right.
And ex gratia was also given to the ones with minor injuries?
Everyone.
The breakup which you gave, your chart is not complete there. In your chart.
And why is 50 crores lying with the RBI?
The interest amount over a period of time. And
No,
then I've
no,
got
no.
some
I'm not
425
able
people
to see.
did
You
not
have paid
claim.
this amount. This
I
is
will
out-
explain that. That's
This is outflow gone. So you should, all that should have been used in any
the
case.
question. One question is about the amount which has come into our kitty. How have we disbursed it? How the expenditure has taken place? So even if the amount 50 crores lying there, whether it is required to be paid over, in what manner? That's a different question. Why am I on a fundamentally different issue?
Mr. Attorney, there is
If we have paid, suppose we not paid the equity at all.
some difficulty. Some difficulty. If you just, Mr. Attorney, during the lunchtime, just check up on these figures. There's some difficulty in these figures.
What do you want to explain on the figures?
Just to assist the Lordship.
No, what is the figures? If you have some better definition of the figures.
I'll just come. Now, if your Lordship look at this table, but what happened that initially when the settlement. Right, sir. I'm audible like.
Yes.
Yeah. Milord, initially the settlement came and then there was, Milord, hue and cry that how the settlement has been arrived at. So much of this honorable court took cognizance of the situation. And they said on the basis of assumption that this figure has been arrived at. Now the court was supposed to determine that what is that assumption. So these figures which have been given, if you Lordship look at this table, 3,000 etc. which has been given is based on, my lord, the judgment which was given, which is on 4th of May 1989. I'll just read out, my lord.
Correct.
And what the court said that we have arrived at this figure on the basis of assumption. And if the basic assumption is ultimately disturbed in the sense we find.
No, Mr. Parekh, we are not on that.
No, Milord, I'm just.
We are on the quantum of the amount, not the figures.
No,
of
Milord,
the-
I'm just
under
explaining.
the
I
other
think
head.
my explanation will clarify.
Yeah.
So this, Milord, when we look at this number which is given here, assume this number is, Milord, based on what the judgment of this honorable court says. Now, the average amount which has been mentioned, this is the average amount. Again, the court said that in case of death, the average amount will be 2.33. So therefore, Milord, when they multiplied, the total amount came to 725. This is, Milord, for the number which is mentioned here, that is 3,000 sectors, that these are the total amount which has to be given. Now, what happened thereafter, Milord? This 725 was not disbursed immediately because it was subject to, Milord, the determination of claim by the tribunal. So the determination process was going on. So this 725, Milord, the interest accumulated, the interest became, so this amount.
Became larger.
Yes, Milord, it became larger. So suppose the amount was immediately disbursed, for example, in case of death, 233, then, Milord, the entire amount of 725 could have been disbursed. Because, Milord, the interest became more. Therefore, the question is that interest amount who is entitled to, whether the same number of persons who are mentioned here are entitled to that interest. So this is, Milord, a separate thing like 50 crores. Now, 50 crores will go to the persons who were really identified by this honorable court on assumption that these are the figures. Now, what happened thereafter, Milord? The process of determination started. Now, the process of determination by the tribunal came out this particular figure, which is mentioned in column D, that is 5,295, etc. And then for somewhere, Milord, the figure has gone up, somewhere the figure has gone. Like in case of simple injury, it has become tremendous, and lordships are putting the question that how this figure became so much. Now, this is based on the determination which has been done by the tribunal on the basis of, Milord, documents which are produced.
So, what has happened, Mr. Parekh, is if you keep out this category of minor injuries, there is actually excess availability of about 275 crores. I've done the minus and plus only,
Yes,
basic mathematics. It has been so. In the wisdom now, it was decided that while it was envisaged that minor injuries may only be 50,000, effectively minor injuries was categorized as something where there is an element of trauma. One is not saying this is illogical.
20,000
It is.
something.
So practically everybody who was in the area was given that. Therefore, the number of minor injuries cases rose from 50,000 to 5,27,000. There can also be another reason, as the learned attorney said, that a lot of people may have claimed under different heads, maybe under different heads. And via media was that put all these people as having gone through trauma, and therefore they will get some amounts, which is about 20,000 rupees. So give 20,000 to everybody who was in the area. Practically, that is what has happened.
Each claim
While
was
the
determined
claimants
not
under
separate.
different actual heads of permanent disabilities and others, the number of assumptions have been very different or lesser than what actually has been deciphered.
Milord, may I just clarify again from this thing? Now, if we, Milord, stop there, that suppose, Milord, the number was only 3,000, 30,000, etc., then this entire amount of 725 should have gone, Milord, to the persons who have been mentioned in A.
Not
Entire amount
necessarily,
should have
no,
gone to them.
No.
Yes, Milord.
No,
Because.
not necessary. Not necessary. You see, these were tentative figures, you are right,
Yes.
but the figures changed.
I am coming to
Figures
that.
changed
Milord.
because of the fact that the number of persons assumed cases also underwent a
Milord,
change.
I'm coming to that, Milord.
On verification, the
I'm
assumed
just coming
cases
to-
were not
Lord,
found
just
to be
give me
so
2
many
minutes.
of the more drastic category. But they fell under persons who were, let us say, had gone through a process of trauma.
Milord,
We are not doubting the government should
going on
not
the
try to
basis-
rehabilitate them.
Milord, I am going, Milord, just kindly give me, Milord, 2 or 3 minutes, I'll clarify. Suppose, Milord, the assumption which is mentioned here, 3,000, 30,000, etc., was correct, and the figures were only that much. Suppose we go, Milord, on that basis. Then it will be that the 725 crores which have been given as part of settlement will be disbursed, Milord, according to the figures which are given in A,
Correct.
including the interest part of it. Am I, Milord, correct to that
Yes,
extent?
yes.
Now we come, Milord, and this is the amount which has been pointed out by this honorable court, which is in C. has to be given case of death, etc.
Hmm.
Now, what has been done is that after determination, this figure has come 5295. We'll take only case of death. So therefore, the difference is 2295. Now, this 2295 has been multiplied with 233, and this figure has been arrived at 53.47. That's how, my lord, the entire whatever was determined by this honorable court has to be given as compensation has been put, my lord, as 675 total. Now, this 675, that is what has been said in curative, is the amount based on whatever this honorable court exercise did in suo moto has to be paid, which is in addition to number which has been given to payable to those who were assumed 3,000, etc.
Only
So this
thing,
figure
only
comes
thing
to
we've understood it. The only
Lordship,
thing I'm
Lord,
telling you
yes.
is that all this variation, somewhere less was being spent, somewhere little more was being spent, but the figure is drastically different because practically everybody who would be in the affected area, a conscious decision was taken to give them at least for minor injuries. Therefore, people who have gone through a trauma would get some amount at least. That's the principle.
Not done by government. I want to make it clear. Determination of this trauma has been done by the tribunal.
Maybe by the tribunal. I'm not saying that government will determine it.
And I must make it clear, my lord. The figure which has been given in D, nobody is claiming that the number has increased. Nobody is claiming. The number, because this number has been determined by the tribunal, and the tribunal stopped functioning after a particular point of time. They stopped taking claims. So therefore, my lord, the number which is mentioned here is static. Somewhere, my lord, we have said so, which SLP will be heard later on, that suppose a case of grievous hurt has resulted into death, what will happen in those cases? Because the tribunal is not functioning, who will determine? That question Lordship will decide after the Constitution Bench judgment. Because Lordship said that we will decide this SLP after the judgment by the Constitution Bench of curative petitions. So, but then today we are not concerned with that.
Yes, yes.
Today we are concerned only with the figure, and figure remains static.
Today we are concerned with whether anything more and above in a curative petition can be parceled on to the others.
That
That's
emanates,
all.
my lord, in my humble submission from the order which was given on 4th of May, which will, suo moto, which your lordships may read, because that will throw the light on the entire.
Okay, the attorney will read the the main two orders after lunch.
Very good.
Yes. I'm grateful. I'm grateful.
Sorry for the delay. I got caught up in some meeting.
Is when on the early occasion, your lordships put me a question, and is there a real need and a pressing concern as to this court should hear this matter? I said I have myself applied my mind and studied this matter from various angles, and I know there are some issues on which there are no answers readily available, either on the statute book or some precedents. But as I myself try to travel through this mass of documents and look at how in different contexts, in different jurisdictions, cases such as these, either of this magnitude or of a lesser magnitude, has been dealt with by the courts. I had some questions, but I thought the only way to place them before the court is to raise them as questions and probably, if possible, elicit some answers, depending upon the broad contours of the case.
I don't think courts are averse to extending the envelope to examine cases and try to innovate solutions wherever possible.
Your lordship, right.
I can certainly say this. There's no hesitation. But it depends on the jurisdiction you're dealing with.
Absolutely. I know that.
If say I was sitting in a 226 for the first time, I would certainly not hesitate to mold the release wherever required. If I'm sitting in a suit, I'm far more constrained because it's the civil proceedings which will operate. In a civil revision, different aspects operate. On the lighter side, I used to often tell my colleagues that there is a maryada of every jurisdiction.
You're right.
We are as judges bound by the maryada of that jurisdiction. That is what is required. Now here, some in a suit, in proceedings arising out of suit, this court arrived at a settlement, or rather the parties arrived at a settlement and this court adopted the settlement. That's all that has happened really. Maybe a little push here and there from the court, it's adopted. Review filed after that, some aspects examined and review after many years. And now we are faced with a jurisdiction of curative. Please appreciate as the apex court, what we say in one matter has a lot of ramification in others.
I deeply appreciate that. I know that.
So I'm just telling our constraints. The constraint arises from the fact, would I do it differently in a different jurisdiction? I don't know. How will I do it within the jurisdiction in which I am sitting at the moment? This is concern of all of us. That we should not be stepping into something which is impermissible, given the constraint to the curative jurisdiction, and open another Pandora's box for
at the same time
so much more.
No, okay, that's right.
Yet try to see if there is a point of view which is
at the same time,
can that be done in these proceedings, or you have some liberty, if at all something is available in law to you, it's up to you to choose to do it in some other proceeding. This is what
what was
concern is.
all this concerns certainly had been points of reflection for me too. But as your lordships use that very interesting expression of the maryada of the jurisdiction. So just before I go into that question, page 45 of volume 1,
Yes.
your lordships knows that how post Basappa versus Nagappa, and saying we no longer bound by the technicalities of the Indian English administrative law writs. And in Bandhu Mukti Mocha, lordships looking at Article 32 jurisdiction. Much later, the way the 32 jurisdiction has been so fashioned and applied in order to do justice.
No,
So maybe there are cases when
the jurisdictions also evolve.
Right.
I'm not
I just
disputing that jurisdiction can evolve, but whether a curative jurisdiction, to what extent it can evolve, will be
I
the
understand.
question.
I understand that. But my endeavor is only to say if this court were to say something which will be clearly confined to dimensions of a case like this, even one says that there are circumstances when Engineers Council and the court inclined to do justice, Article 142, cause or matter. So you can always read something into those provisions and do for the purpose of doing complete justice. That's how law evolves. That's how the whole common law growth both in tort law and in contract law. So one looks at it like that. So nobody thought when Donago and Stevenson decided, then it will open up a long line of reasoning and logic for. And then I remember one early case on fiduciary jurisdiction, somewhere in the 25 English reports, and then Chancellor was unseated because he was acting in breach of the trust. So the fiduciary, relationship concept has also grown. It has expanded both in terms of unjust enrichment, restitution, and so on and so forth. That's how the needs of a given point of time in doing justice will certainly evolve. I at the same time, certain limitations on how you read into certain provisions of the law or a given demands of a case, all that limitations will be kept in mind. But what was worrying in this case is that if I look at how from May 4, 1989, when the court first gave a stamp of approval on the settlement thereafter for a long period of time, these issues have remained unanswered for a number of reasons. So in my very respectful submission, this curative petition is one of the most essential endeavors to get at answers from this court. So, and I'll also place for Lordship's kind consideration some of the doubts which have come about the categorization, how they have happened. So under the Act and under the scheme, there are provisions to do that. And soon after the settlement, on the basis of the settlement arrived at, so the broad outlines of the contours of the scheme, which talks about what kind of categorization is available for looking at whether a settlement for a trial, the Act would have probably thrown light on that. When a trial would have been probably governed, by and large, by the provisions of the Act and the scheme, where the Union of India was acting in a participatory capacity. So I'll show you all those provisions, therefore throw a good deal of light on how they have happened in the way they ought to have happened. There's nothing uneasy about the way they happened. One probably could not say the change from one number to other number was something besides the point. It's very difficult to say that. So if they fall within a statutory framework and a scheme, and no blame could be laid at the doors of those processes, and I think for all practical purposes, this court will proceed to assume that the culmination of the welfare commissioner processes are to be assumed to be correct and valid for the purpose of having a second look at the whole settlement. Let me take place your lordship to page 45 of volume 1, the first volume 1 of respondent's compilation. Which judgment begins at page 45, but it is styled as an order at page 47.
(47) of volume 1.
Volume 1 of the
Separate compilation.
compilation of respondent number 1. So we have at page, a lot have that page?
Yes.
So we can turn over to page, you don't have? Oh, your mark. I have it. But it's the same judgment we have. Please turn over to page 48, paragraph 3. Yeah, 1989 3 SEC.
This is
That's the first
1989
settlement order.
3 SEC 38. Compilation page 45. Yes.
Yeah.
What do you want us?
Paragraph 3 at page 48.
Yes.
You're
The
not
court
reading
takes notice of the order passed, the first order.
You're not reading the 14-15 February order?
No, that is the earlier order. That's being referred to here. Para 3 refers to that order.
Yes.
This court, by its order dated February 14, 1989, made in those appeals directed that there shall be an overall settlement of the claims in the suit for $470 million of US dollars in termination for all civil and criminal proceedings. The opening words of the order said, Having given our careful consideration for the several days on the facts and circumstances of the case before us, for the parties to these proceedings, including the pleadings of the parties, the mass of data placed before us, the material relating to proceedings in the courts of the United States of America, the offers and counter-offers made within the parties at different stages during the various proceedings, as well as the complex issues of law and fact raised before us and submissions made in, and in particular the enormity of human suffering occasioned by the Bhopal gas disaster, and the pressing urgency to provide immediate and substantial relief to the victims of the disaster, we are of the opinion the case is preeminently fit for an overall settlement, with the parties covering all litigations, claims, rights, and liabilities relating to and arising out of the disaster. Then it appears for the reason that persuade this court to make the order for settlement should be set out, those who have sought a review might be able to effectively assist the court in satisfactorily dealing with a prayer for review. The statement of the reasons is not with a sense of finality as to the infallibility of the decision, but an open mind to be able to appreciate any tenable and compelling lighter factual infirmities that may be brought out, calling for a remedy in review under Article 137 of the Constitution. Points which propose set out brief reasons as follows. How did the court arrive at sum of $470 million US for an overall settlement? Why did the court consider this sum of $470 million as just, equitable, and reasonable? Why did the court not pronounce on certain important legal questions of far-reaching importance said to arise in this appeal as to the principles of liability of monolithic, economically entrenched multinational companies operating with inherently dangerous technologies in the developing countries of the third world, a question said to be of great contemporary relevance to the democracy of the third world? There's yet another aspect of the review pertaining to the part of the settlement which terminated the criminal proceeding. Questions raised from the point of review petition prima facie merit consideration, and we should therefore abstain from saying anything which might tend to prejudge this issue one way or the other. The basic consideration motivating the conclusion of the settlement is the compelling need for urgent relief. The suffering of the victims has been intense and unrelieved. Thousands of persons who pursued their own occupation for a humble and honest living have been rendered destitute by this ghastly disaster. Even after 4 years of litigation, basic questions of the fundamentals of the law as to the liability of the Union Carbide Corporation, the quantum of damages yet being debated. These, of course, are important issues which need to be decided. But in thousands of innocent citizens were in near destitute condition, without adequate substantial needs of food and medicine, of the every coming morrow haunted by the spectre of death and continued agony, it would be heartless abstention if the possibilities of immediate sources of relief are not explored. Considerations of excellence and niceties of legal principle are greatly overshadowed by the pressing problems of very survival for a large number of victims. These are very important concerns expressed by the court. The lost delays are indeed proverbial. It has been the unfortunate bane of judicial process in ordinary cases, where the evidence consists of a few documents and the oral testimony of a few witnesses requires some years to realize the fruits of litigation. The next few sentences. The present case one where the damages are sought on behalf of the victims of mass disaster and having regard to the complexities of the legal questions involved. Any person with an unbiased vision would not miss the time-consuming prospect for the course of the litigation in his sojourns to the various courts both in India and later in the United States. Then paragraph 10. This court considered it compelling duty both judicial and humane to secure immediate relief. In doing so, the court did not enter upon any forbidden ground. Indeed, efforts been earlier made in direction by Judge Keenan in the United States and by the learned District Judge Bhopal. What this court did was a continuation of what had already been initiated. Even at the opening of the argument in the appeal, the court had suggested to the learned counsel and both sides reach a just and fair settlement. Again, when counsel met for rescheduling of the hearing, the suggestion was reiterated. The response on both sides was positive in attempting to settlement, but they expressed a certain degree of uneasiness and skepticism with the proposals and the prospects of success in view of the past experience of such negotiations. There have been uninformed and irresponsible criticism of the attempts at settlement. Attorney submitted and even the most bona fide, sincere, and devoted efforts were likely to come in for motivated criticism. Then the court asked the counsel to make available the particulars of offers and counter-offers made on previous occasion for a mutual settlement. Then counsel for the parties furnished particulars of the earlier offers for the overall settlement what been considered reasonable. Progress made by previous negotiations graphically indicated. Then a few lines later, Nariman stated that his client would stand by the offer of $350 million US Also, submitter's client has also offered to add appropriate interest to the rates prevailing in the USA, sum of $350 million US, to raise the figure to $426 million. Nariman stated that the client was the view that the amount was the highest it could go up. In regard to the offer of 462, Attorney General submitted he could not account this offer. Submit any sum less than 500 million would not be reasonable. Third counsel, both the parties stated they would have to leave it to the court to decide what should be the figure of compensation. The range of choice for the court in regard to the figure was therefore between the maximum of $426 million offered by Sri Nariman and the minimum of $500 million suggested by the learned Attorney General. In these circumstances, the court examined the prima facie material, very important, the prima facie material as to the basis of quantification of a sum which, having regard to all the circumstances, including the prospect of delays inherent in the judicial process in India, and thereafter in the matter of domestication, the decree in the United States for the purpose of execution, and directed that $470 million which upon immediate payment and with interest over a reasonable period pending actual distribution would aggregate very nearly to $500 million rupee equivalent, approximately 750 crores, with the learned Attorney General that suggested be made the basis of the settlement. Both the parties accepted this direction. Therefore, this flew from an order of the court. The settlement proposal was considered on the premise that government had the exclusive statutory authority to represent and act on behalf of the victims, and neither counsel had a reservation as to this. The order was also made on the premise that the Bhopal Gas Leak Disaster Act 1985 was a valid law. In the event the act is declared void and the pending proceedings challenging its validity, the order dated so-and-so would require to be examined in the light of that decision. We should make it clear that if a material is placed before the court from which reasonable inference is possible, the Union Carbide Corporation had at any time earlier offered to pay any sum higher than the outright payment of 470, this court would straightaway initiate suo motu action requiring the concerned parties to show cause why the order dated should not be set aside and the parties relegate to their respective original positions. The next question is as to the basis on which the court considered the sum to be a reasonable one. This is not independent of its quantifications. The idea of reasonableness for the present purpose is necessarily a broad and general estimate in the context of the settlement of a dispute and not on the basis of an accurate assessment by adjudication. The question is how good or reasonable it is as a settlement which would avoid delays, uncertainties, and assure immediate payment. The estimate in the very nature of things cannot share the accuracy of an adjudication. Here again, one of the important considerations was the range disclosed by the offers and counter offers between 426 and $500. The court also examined certain materials available on record, including the figures mentioned in the pleading, the estimate made by the High Court, and also certain figures referred to in the course of the argument. There are a large number of claims under the Act. In the very nature of the situation, doubts that a sizable number of them, or either without any just basis, where otherwise exaggerated, could not be ruled out. It was therefore thought not unreasonable to proceed on some prima facie undisputed figures of cases of death and of substantially compensatable personal injuries. The particulars, therefore, this is very important, prima facie. The particulars of the number of persons treated in the hospital was an important indicator on its behalf. This court had no reason to doubt the bona fides of the figures furnished the plaintiff itself in the pleading as the number of persons suffering serious injuries. If you are looking at the time when the settlement was arrived at, the particulars, the number of persons treated in hospitals is the only way the indicators have been made available to the court. So from the order of the High Court in the admitted position, so and so, a reasonable prima facie estimate of the number of fatal cases and serious personal injury cases was possible to be made. The High Court said, then, Your Lordships, in the circumstances, leaving a small margin for the possibility of some of the claims relating death and personal injuries made by the multitude of claims before the Director of Claims being spurious, there is no reason to doubt that the figure furnished by the Plaintiff Union of India in an amended plain can be safely accepted for the purpose of granting the relief of interim payment of damages. It has been stated by the Plaintiff Union of India, the total number of 2660 persons suffered agonizing and excruciating deaths, and between 30,000 to 40,000 sustained serious injuries as a result of the disaster. So that was the initial account. There is no scope for any doubt that the cases referred to, those of serious injuries, include both types of cases of permanent, total, and partial disabilities of various degrees, and also cases of temporary, total, or partial disabilities of different degrees. High Court relied upon the evidence and claims amended pleadings to this reason its prima facie finding. Thus, then in assessing the quantum of interim compensation, High Court did not adopt the standards of compensation usually awarded in fatal accident section, the personal injury actions arising from the Motor Vehicles Act. Well known that in fatal accident affections where children are concerned, the compensation awardable is in conventional sums ranging from 50,000 to 30,000 each case. In the present case, larger number of deaths of children at a very young age. Even in the case of adults, according to the general run of damages in comparable cases. I've read some of the cases where the commissioner looked into divergent evidence, and it was really agonizing to find out how somebody just born, as infantile one could be, you lose your child. So the damages assessed in the visual and the usual multiplier method in the case of income group comparable so and so would be anywhere so and so. Then kindly turn to page 21. Paragraph 21. The figures adopted by the High Court in regard to the number of fatal cases and cases of serious personal injuries do not appear to be disputed. These data and estimates of the High Court are of particular significance in the statement. Then again, it was not disputed before that a total number of fatal cases was about 3,000, and of grievous and serious personal injuries as verifiable from the records of the hospitals of cases treated at Bhopal was the neighborhood of 30,000. It would not be unreasonable to expect that persons suffering serious and substantially compensatable injuries would have gone to hospital for treatment. It also appeared that within about 8 months of the occurrence, a survey had been conducted for purpose of identification of cases of death and grievous and serious injuries for purpose of distribution of certain ex gratia payments sanctioned by the government. These figures, but it appeared less than 10,000. These circumstances are a rough and ready estimate. This court took into consideration the prima facie findings by the High Court and estimated the number of fatal cases at 3,000, where compensation could range from rupees 1 lakh to 3 lakhs. This would account for rupees 70 crores. And that's the tabular column which I showed at page 2 of my statement. And nearly 3 times higher than what would otherwise be awarded in comparable cases in motor vehicles accident claims. Death is an inexorable finality. Then Lordship may, at the last line in para 23, but the High Court is in estimating the value of compensation adopted a higher basis. So far as personal injury cases are concerned, about 30,000 is estimated as case of permanent, total, or partial disability. Compensation ranging from rupees 2 lakhs to rupees 50,000 per individual, according to the disability is total or partial, and degrees of the later was envisaged. This alone would account for rupees 250 crores. In other 20,000 cases of temporary, total, or partial disability, compensation ranging from 1 lakh let me read it and then come. Depending on the nature and extent of the injuries and extent and degree of the temporary incapacitation, accounting for a further allocation of 100 crores was envisaged. Again, there might be possibility of injuries of utmost severity, in which case of rupees per individual might have to be considered. Rupees 80 crores additionally for about 2,000 such cases were envisaged. So all these were on a hypothetical basis. A sum of rupees 500 crores approximately was thought of as allocable to the fatal cases, and 42,000 cases of such serious personal injuries leaving behind in their trail total or partial incapacitation, either of permanent or temporary character. We consider that some outlays would have to be made for specialized institutional medical treatment for cases requiring such expert medical attention and rehabilitation. 25 crores for the creation of such facility within envisaged. Now turn to paragraph 27. Such case of claims do not apparently pertain to serious case of permanent temporary disabilities, but a case of a lesser serious nature comprising claims of minor injuries, loss of personal belongings, loss of livestock, etc., where there is general allocation of rupees 225 crores. If in respect of these claims, allocations are made rupees 20,000, 15,000, so on. So persons or claims in each category accounting for about 1.5 lakh more claims, the sums required would be about 225 crores. Looked at from another angle, if the corpus of rupees 750 crores along with the current market rates of interest on corporate borrowings of say 14% or 14.5%, is spent over a period of 8 years, it would make available rupees 150 crores each year, or even if interest alone is taken, about 110 crores per year, could be sent year after year perpetually towards compensation and relief to the victims. The court also took into consideration the general run of damages in comparable accident claim cases and cases in the workmen's compensation laws. The broad allocations made are higher than those awarded in all such claims. These apportionments are merely broad considerations, generally guiding the idea of reasonableness or the overall basis of settlement. The exercise is not a predetermination of the quantum of compensation amongst the claimants, either individually or category-wise. Something as open as anything could be. No individual claimant shall be entitled to a particular quantum of compensation if it's found to fall within either broad categories. Determination of actual compensation payable to the claimants are done by the authorities under the Act on the basis of the facts of each case, with a reference to the hypothetical quantifications made only for the purpose of an overall view of the adequacy of the amount. Therefore, the overall view of the adequacy of the amount on the one hand, and the process of consideration of the claims on the other hand, under the Act, they stand on two different footing. These are the broad and general assumptions underlying the concept of justness of the determination of the quantum. Is the total number of cases of death or a permanent, total or partial disabilities, or what may be called catastrophic injuries, is shown to be so large that the basic assumptions underlying the settlement become only unrelated to the realities. The element of justness of the determination and of the truth of its factual foundation would seriously be impaired. And precisely what we are trying to place before your lordships. The justness of the settlement is based on these assumptions of truth. Indeed, there might be different opinions on the interpretation of law or on the questions of policy, or even on what may be considered wise or unwise. But when one speaks of justice and truth, these words mean the same thing to all men whose judgment is uncommitted. Of truth, so and so, then I'll skip that. Then paragraph 31. 33, why am I one? Para 34, again the concerns of the court to look at the legal framework. Indeed, there is also a need to evolve a national policy to protect national interests from such ultra-hazardous pursuits of economic gains. Jurists, technologists, and other experts in economics, environmentology, futurology, sociology, and the public should identify areas of common concern and help in evolving proper criteria which may receive judicial recognition and legal sanction. One aspect of this matter was dealt with this court in MC Mehta, which marked a significant stage in the development of the law. But at the hearing, there was more than a mere hint at the submission of the Union Carbide, that in this case the law was altered, only the Union Carbide Corporation in mind, and was altered to disadvantage even before the case had reached its court. The criticism of the Mehta principle perhaps ignored the emerging postulates of tortious liability, whose principal focuses the social limits on economic adventurism. Very, very important postulate. There are certain things that a civilized society simply cannot permit to be done to its members, even if they are compensated for their resulting losses. You may note a passage in Theories of Compensation. It would hardly be wrong to presume that we as a society can do anything we like to the people, just so long as we compensate them for their losses. Such a proposition would mistake part of the policy universe for the whole. The set of policies to which it points, policies that are permissible but only with compensation, is bounded on the one side by a set of policies that are permissible even without compensation, on the other side by a set of policies that are impermissible even with compensation. Very important considerations. So, but in the present case, the compulsions of the need for immediate relief to tens of thousands of suffering victims could not, in our opinion, wait till this question, vital though they are, be resolved in the due course of judicial proceeding. The tremendous suffering of thousands of persons compelled us to move into the direction of immediate relief, which we thought should not be subordinated to the uncertain premise of the law, and when the assessment of fairness of the amount was based on certain factors and assumptions not disputed even by the plaintiff. Then kindly turn to paragraph 38. (37) Very well, I'll read this. 37. A few words in conclusion. A settlement has been recorded upon material and in circumstances which persuaded the court that it is a just settlement. So looking at materials which are available to the court at that point of time. This is not to say this court will shut out any important material and compelling circumstances which might impose a duty on it to exercise the powers of review. We have reached that point. Like all other human institutions, this court is human and infallible. What appears to the court to be just and reasonable in that particular context and setting need not necessarily appear to others in the same way. Which is right in the ultimate analysis is to judge by what it does to relieve the undeserved suffering of thousands of innocent citizens of the country. As the learned author said, in this imperfect legal setting, we expect judges to clear their endless dockets, uphold the rule of law, and yet not utterly disregard of need for the discretionary justice of Plato's philosopher king. Judges will be sometimes cautious and sometimes bold, must respect both the traditions of the past and the convenience of the present. But the course of the decisions, of course, cannot be either altered or determined by agitational pressures. The decision is wrong. The process of correction must be in a manner recognized by law. I suppose the curative process is a manner recognized by law. Here, many persons and social action groups claim to speak for the victims, quite a few in different voices. Factual allegations, and with they address their approach are conflicting in some areas, becomes difficult to distinguish truth from falsehood, distinguish as to who speaks for whom. However, I mean, all these preceding paragraphs only express the anguish, the concern, and the despair, and the utter need for an immediate relief the court thought is something indispensable. So, summing up in paragraph 38, however, although to invoke the corrective process in accordance with law shall be heard, and the court will do what the law and the courts of justice requires, the matter concerns the interest of a large number of victims of a mass disaster. The court directed the settlement with the earnest hope that it would do them good and bring them immediate relief, but tomorrow might be too late for many of them. But the case equally concerned the credibility of the public confidence in the judicial process. Owing to the pre-settlement procedures being limited to the main contestants in the appeal, having the benefit of some contrary or supplemental information or material, very important, the benefit of some contrary or supplemental information of material, having a crucial bearing on the fundamental assumptions basic to the settlement, have been denied to the court, and that as a result, serious miscarriage of justice, violating the constitutional and legal rights of the persons affected has been occasioned, it will be the endeavor of this court to undo any such injustice. But what we reiterate must be a procedure recognized by law. Those who trust will not have a cause for despair. So I try to gather from this judgment, the court left open 2 or 3 important considerations, that if contrary or supplemental information material which has a crucial bearing on the assumptions which persuaded the court to reach at a settlement between the 2 conflicting figures of propositions, and if that is made available to the court through due process of law. So would not the court say that, well, yes, the assumptions are wrong, and if other set of materials are available, we would rather look at these figures rather than the assumption. And that's the most pressing question before the court. And I suppose when the curative petition was filed, it has paid a good deal of attention to these aspects. We also kindly turn to, just at this point of time, to few provisions of the Act and the scheme under the Act. The Act is in the same volume. I will take your lordship to the review judgment a little later.
Just for our understanding, the review petition prayer.
Let me complete.
Mr. Attorney, just
don't mind.
so that we know.
Don't mind. Let my thought process not be interrupted, please.
There's no thought process.
I have a thought process.
The review challenged the settlement and said, set aside the order affirming the settlement. Is the union still pressing that?
He has said that he is not.
Okay. Then all these passages were in the context of review petition saying this settlement has been wrongly affirmed by the court.
No, no, no. This is a order which affirms a settlement which was passed as a matter of order on 14th of February.
No, it's a signed settlement, it's reproduced, which has not been shown.
Kindly turn to the Act at page 174. I mean, I don't know whether a signed settlement makes a difference. If a settlement is bad, for any reason whatsoever, and the judicial process endorses a settlement which is illegal, which is unjust,
That's not the
and therefore let us not get.
You can't traverse both the paths, Attorney. You said
I,
that you don't want to traverse the path of reopening the settlement, but that you want, for whatever reason you disclose, why in a curative petition, further amounts can be loaded on them.
no, if this court,
monetary compensation.
right, sir. If this court, while affirming the settlement in this order, had said, well, we will not certainly reconsider this matter because the settlement in our understanding is based, whether in assumptions or not, any other legal procedure available will be open to the claimants and the Union of India to be pursued. The court has not said that we will do the review. We will do the review. It was not relegated to some other procedures of law. Then what fairness would have been then emanated if the court were to relegate parties, if in the event of a settlement being unsettled?
The difficulty is, you say the procedure is, the fairness of procedure is not there, then you open a settlement. This is the whole problem. This is not some settlement which
If
the court only in some sense gave its imprimatur to the settlement, which was agreed to between the parties. Court did not say you take so much, you take so much.
the court,
That's not the court what given to you.
there
You
is
negotiated the settlement.
an element of court's intervention which made it possible. The court also applied its
Every day
mind.
happens.
The
Tell
court
me that
also
every
applied
day
its mind.
We settle so many matters where we just push
No,
the parties
let me
on
put
the
it like
parties
this.
to come together. That's all.
Let me try to understand. The court is now at a situation when to ask parties to go for a long trial procedure and then uncertainties in the principles of law application, jurisdiction,
We don't
liability,
even know, attorney,
all
we
that.
don't even know whether it's available or not. We are saying if you feel there is a procedure, that's your call.
No,
If you
therefore, I ask myself a question. Well, also put it to me like this. Say, well, the Union of India volunteered for a settlement. Then you are completely estopped, foreclosed from pursuing any process under the Act or the scheme which would have possibly opened up and shown the injustice of the basis of the settlement. And that will be a call on which I don't know whether the court would completely foreclose the Union of India. So the settlement breathes a lot of life into the need for bringing to a close at some point of time, at an immediate point of time, where people get some relief without waiting for the uncertainties of. Therefore, that's the essence of the entire settlement.
Settlement cannot be that, look, we, in the claimants being in need of it, we are authorized to negotiate on their behalf. We have negotiated so that we can get the settlement now, so that we can challenge it later.
No.
How does that deal?
No. I don't think. No, Your Lordship probably may not look like that. Did I bargain for a settlement on subject to certain conditions? No. The court says we know that our assumptions can be wrong.
There's one difficulty. Yes, you're right. It does appear that there's a leeway given. Crucial bearing on fundamental assumptions basic to the settlement. Now, in this settlement, there were fundamental assumptions. You may be right that the figures with regard to the deaths, etc., was stated there. There was also a calculation made with regard to the damages portion, the compensation portion. Now, if you unilaterally decide to change it, because somebody feels that it should be enhanced 26 years down the line, then can that be the fundamental basis for change of settlement?
First, I'll try to answer that question. I'll try to answer that.
Yes, the quantification of the compensation amount was clearly stated here. It doesn't take you 26, 27 years to redo or rethink about the compensation figure. I can understand the figure with regard to the deaths, etc., have undergone a change. That's understandable. That can change. There's no doubt about it. It can change. And we'll assume that the figures given by you as far as death is concerned. But the figures with regard to minor injuries.
I'll explain. I will explain.
Just one.
I'll explain.
The figures with regard to drastic injury. Somebody may say then we require examination. Look, what has happened? The minimum, I told you that from the website I could make out, the taxable income in that year was 15,000.
I would have definitely looked at
Yes,
that
I've-
angle.
I've
I would
done
have
it,
definitely
yeah.
looked at
And even
that
in
angle.
1999, the taxable income was 22,000.
Uh,
So
we are-
now look at the thing. From 50,000, you go to 5,27,000. Apparent, it's quite apparent that those were given the
You-
criteria adopted must
the
have been very
56
little.
I just want to tell you, Lordship, what happened.
But you can't say that, look, 26 years down the line, I've decided to increase the sum from 1 lakh to 3 lakhs, and that refers to the MSCT compensations.
Today,
And that will increase it now to 10
today
lakhs.
I am not on the question of increasing the quantum of compensation. We are first on the question of the figures. On the question of figures, and if through due process of law under the Act and the scheme, which
yes.
this court sanctioned.
But one thing is also very surprising. The occurrence is of 84. The compromise is in 89. Almost 5 years down the line. Do we accept that the government or all the organizations were not aware of the minor injury figures?
No, there was too many issues which were not
5
clear
years
at that
down the
point
line,
of
it
time.
speaks about
Your Lordship,
unburdened.
today, even today, when
Then
I
it reflects
even
on the
even
governance level.
with great respect, even today, when I had an interaction with the ICMR scientists, all over the world, there are several unanswered questions on medical evaluations of certain categories of ailments and disabilities. Therefore, the asbestos case is one of the most classic examples. So, therefore, to say that in 1985 and 86 or soon thereafter, or when the settlement arrived in 1991, everything was written on the slate. I say with no sorry. It was not like that.
Cannot be, but you can't have a scenario where you say, well, 50 years down the line, we have now come across more developments, so we open it up. That's what we are trying to pull you. And that date, did you take a prudent decision on that date
The
to settle
figure-
or not?
no.
You are not saying
No,
that
no, no.
our decision was motivated.
No. That's not what. Please don't.
I'm saying so. It's not that.
And the settlement was also for future litigation also coming up and future claims
Everything is
also
taken
coming
care
up.
of.
Now, let
That's
us
what
look
the
at it like
settlement
this.
says. You need to
The
read order
total-
of 14th February and 15th February.
There was
And then
there was a period before which persons who said they were suffered by reason of a gas leak were required to be registered. That period was over. So all those who got registered before the said period, and that happened till 1996, 97. It has to happen like that. Because after the settlement commissioner, the whole process of registration was kept open. So earlier, whatever was again ad hoc, and on that ad hoc basis, the assumptions were placed before the court.
How long?
So therefore, in
See,
19
it's your settlement commissioner in a sense.
yes,
Now, how long is it expected to be kept open?
well, by 97, the registrations got concluded.
Yes.
Then all these cases registered before 97 were being examined.
So you
Oh,
are saying registration took 13 years.
No. By 2000,
84 is the episode. Yeah. So you say registration took us 13 years to determine who are the ones affected.
hmm? No, this is not. What about the 10 lakh cases?
Attorney, if I may
One.
say so, populism cannot be the basis of judicial review.
By the time this
judicial curativeness.
By the time the settlement came to be arrived at, so between 85 to 86, there are about 6 lakhs persons who
Inform the
I'll
court.
give-
I'm sure the attorney can look into it. There are news reports which say, after your lordship's order saying we will not hear the NGOs. There were protests held saying the NGOs are not being heard, and the government assured them we will place all your papers before the court.
Maybe so.
So this is how the breakup figures of
No,
registration
Attorney
before.
General, one
within
more.
8.
You can choose to answer it later. Let us go by what you say.
Yes.
If you see paragraph 4 of this order,
Paragraph 4.
4. Just now you read. You did not
Your Lordship.
open it.
Your Lordship.
The court felt that maybe in future there is possibility that somebody will apply for review, and therefore court thought it fit to record reasons why settlement was accepted.
Yes.
That's what paragraph 4 says. Paragraph 38 says,
That's right.
we go one step ahead. There was a review, in fact. In that review, one of the contentions was that compensation granted is too low. Correct? That review is now dismissed. Now that chapter is over. Review is over. That is reported judgment. In that judgment, court says that if there is shortfall, government must pay. So my question to you, you may answer it later on.
Your Lordship.
My question to you is, if government was so satisfied that, look, we need 600 crores, 600 crores must be paid to these victims. Why government did not pay at that time? I can understand government, after having satisfied that these people are entitled to more compensation, I can understand government should have paid and then come for whatever curative review, whatever you wanted. But in the process, after having satisfied that these people need more money, you have not paid them. And now today you are coming by way of a curative petition, though you are liable to pay as per paragraph 198 of that judgment. And forget about paragraph 198. If Union of India was satisfied that these people are entitled to more compensation, Union should have paid and then thought about recovery from somebody else. Why that was not done?
Let me try to.
You can answer it later on also, but this question you must answer as Union of India.
I'll do that. I'll try to do that
Yes.
because there are some facts which may be brought to your Lord's attention, which will answer this question. Now, sometimes a repetition may bear with your Lordship's it's okay. They like that. 1991, even when the review petition was being heard, I was trying to point out between 85 to 86, 6 lakh people got registered, and the registration got concluded by 1997. So when the review judgment was being heard, the final figure on the number of deaths and the final figures on the shifting of categorization of injuries was not certainly available either to Union of India or to the court.
No, agree. The question is different. At some stage, maybe while filing, at the time of filing this curative petition, or even thereafter when you sat with these calculations,
Yeah.
the government was satisfied that these people should be paid more money. They should be adequately compensated. Why that amount was not paid for so many years? The curative petition is of what year? 2010. For 11 years, why you did not pay them?
No. The government.
Why you
having
waited
felt-
till,
the government having
right.
felt that the inadequacy of compensation. Coming back to that page number 2.
In fact, even with that 10 lakh compensation or 10 compensation for severely affected, it's not making any difference. The figure would have covered up that amount. Real difficulty is at 1,000 crores.
That's right.
Real difficulty is that 1,000 crores paid to 5,27,000. And if you're going to say for minor injuries, even after 10 years, you accepted the applications, it will be impossible for anybody to prove or anybody to say that he was injured or not. Minor injuries is
Then
Either the settlement should have been, look, everybody in that affected area is traumatized. We will take the whole population into account and settle for a figure where everybody gets something. That's not the principle on which you settle. But ultimately you have paid on that principle. You paid on the principle that everybody in some way or the other was affected.
Let's not, probably this doesn't give us the entire scenario.
And you paid this 10 lakhs only 3,000 people, we take it. You did not pay to additional persons who are identified.
5,000.
5,000.
Everybody was paid. Everybody was paid. They came back to Supreme Court and said, we've got 1,500 crores. What do we do? Your Lordship said, pay it all over again. So it was paid all over again. I am not saying so. The Welfare Commissioner's affidavit says so. At page 2622, my Lord Justice Oka's question is answered in page 2622. It says, it is further initially total 6,000 old cases were registered. Then they received so many, and then they go 10 lakh cases were received, of which 574,376 were awarded, which is the same figure in the curative. An amount of 1,548 crores have been disbursed as main compensation. 1,500 was left as surplus. It is submitted while deciding so and so. The court directed to disburse 1,500 to the persons whose cases have been settled, and the pro rata basis, having due regard to the settled, unsettled and pending cases. So the said amount has been disbursed.
I am not able to understand
twice
how
over. Yes, yes.
this payments over a period of time.
So,
It
and
was like this.
your lordship, one
Let
second,
us
your
not-
lordship is told,
Let us not,
it has been brought out that the claimants have been paid compensation twice. Initially, the original amount and again an equal amount of pro rata due to augmentation of the money in the settlement fund with
right,
the
that's
RBI.
right.
This is the government's affidavit to your
Of
lordship.
course it is.
No,
I'm not
actually,
silent from that.
let us
Of
be
course
very,
it is.
very clear about it. This curative petition is for recovery of the amount which you have already paid, or this figure also includes the amount which you want the claimants to receive.
We want the claimants to receive.
So it's only recovery plus additional amount which is payable.
That's right.
Which
Because
you have
the
not
number-
paid,
Because the whole number has undergone.
which you have not paid so far.
So you kindly look at, we have paid an 1.5, what is that?
I'm, my lord, figure, I'm sorry, my lord, please see the figure, 5,74,000 is the figure in the curative. They say 5,74,000 has been paid.
The 574 has been paid.
Yes.
No, to be very frank, the fact that they decided to increase the compensation also to 10 lakhs is fine because they had.
It's all
surplus
paid.
it's surplus funds which were there. It was good that. they paid.
Perfectly fine.
But the real difficulty which is working out is again going back to the.
No, my lord, with that it has been paid.
There were no surplus.
I'm sorry,
at all.
with that it has been paid, 5,74,000 cases includes that increased amount. And that has all been paid is what the commissioner is telling this court. And they still had money, so they said paid all over again.
See, people got less.
Case
between
in
please
claim
let us
one,
not-
nothing is
Let us
paid.
not fudge the figures. People got over 1 to 3 lakhs. Court said, no, you must pay more. And then therefore on a proper calculation, because the amount of earning interest. So on a settlement of all those figures,
I'm sorry.
3,000, so and so, so
Let's
and
pay
so.
more, or because figures were, more funds were available, so you said that we don't have to create something else out of it to disburse the additional amount.
You will also kindly come back to the,
My lord,
kindly
Justice
come back to
Khanna's
paragraph
question.
22.
My lord, Justice Khanna's question, my lord, the charity, the welfare commissioner says 5,21,333 cases were awarded minimum compensation of 25,000 in the general category. That's your minor injury.
That's 25,000.
Yes.
20,000.
25,000 per head paid, and then 25 paid again.
50 has been paid.
Yes. That's what the affidavit is telling your lordships.
And 10 lakhs has been paid to the case.
Yes, my lord, everything. That's because when the claimants came here,
See, there was some delay in payment, so obviously the figures given do not account for
Please-
that interest.
correct.
Please come back to
When
paragraph
the
22. and
claimants
24.
came here, this is
I-
the counter filed by the government.
Let's first get some of the basics clear. Kindly come back to para 22 and 24. Again, the same order. Page 54, paras 22 and 24.
Of second May order? Fourth May.
Instead, by the respondent, earned interest,
Your Lordship, please.
amount deposited by the respondent.
We
earned
paid
interest.
when the dollar was 18.
I'm coming to both the factors.
By the
Secondly,
time it was disbursed, dollar had become 40.
The exchange rate changed. So actually, what was deposited in dollars, because they were lying in
Converted
the
into
RBI foreign exchange account, the actual capacity to disburse in Indian rupees must have gone up 2-3 times.
What was, it was about 3,500 crores in rupees.
When did the dispersal start?
But if your lordship look at the actual disbursement is what we're talking about. In the actual disbursement, even though in page 2 of our statement, the average amount for a person, debt category would be 2,33,000. But in your lordship's direction at paragraph 22 at page 54, talks about it should range from 1 to 3 lakhs. Nobody ever got that money. Therefore, when the creation, nobody ever got that money.
No, when did the actual disbursement start?
92,
92 onwards, the dispersals was taken.
after the settlement.
After 92 onward, dispersals was
Yes,
taken.
yes.
Okay. Now, the money which was deposited was in Indian rupees, partially in foreign exchange. And then it was kept with the RBI and you could withdraw the money. So in case there was any interest accruing or any increased depreciation in value of the Indian rupee would have accrued to the benefit. So do you have the data with regard to the quantum of funds which were dispersed from time to time?
Okay, let me put it slightly different from what my brother put it. How much is the amount from time to time which the RBI has released to you in Indian rupees?
Between 1992 to 2004, 1549.33 crores was disbursed. And on a pro rata basis, because that amount was found to be less than what was due to be paid, an equal amount, out of 1517.93 crores was paid after 2004.
How much is the amount paid dispersed from the amount deposited?
1549.33. 1549.33.
This is from
This includes-
1992 till 2004.
Yeah, 92 to 2004. This includes 725. That amount will be explained by taking into account that 725 crores plus the interest.
Plus the interest.
And what about the exchange rate valuation?
After 2004,
No.
Again,
Exchange,
1517.
what they deposited in dollar terms would be maintained by RBI in dollar terms to be converted into Indian rupees as and when they released it to you.
that's right.
Correct. So in the meantime, the dollar rate also went up.
That's how the interest, that's why the interest portion.
No, are you only counting interest of LIBOR or are you counting the exchange rate also? I wanted to know.
Both. That's how it became 3,000 crore.
It's
If
3,000 crores.
if in terms of the original,
1549. It's 3,000 crores or
After paying
In
1549, they had 1,503 lying in the till. So your lordship said, well, paid again.
basis, because the found was found to be.
No, I'm sorry, my lord is asking.
That's not correct, Attorney. See, the question is, you are saying you have paid 1549 crore.
But the
Have you
quantum,
paid 1549? Have you paid now actually 3,000 crores?
3,000 crores.
the quantum is also to be taken into account. Therefore, if according to
No,
that
as a matter
category,
of figure, how much amount is 1549 or 3,000 crores?
My lord, that one page will answer everything, 2622, if your lordship just sees.
2622 of?
Yes. Volume 11, UCC documents, respondents' documents, reply of 21st November 2011 by the Welfare Commissioner. Let's at least be clear on figures so that, my lord, we know where we lie.
Earlier you had mentioned there was an affidavit of RBI filed,
RBI's letter saying we still have 50 in the till.
which was subsequently released and paid again.
No, now June 22.
That is 50 crores.
Yes.
50.
This is earlier released is in the Welfare Commissioner because when the claimants came and said we are not being paid, the Welfare Commissioner said, what are you saying? We received 10 lakh claims, 5,24,000 claims verified, 1,548 crores paid, 1,503 was sitting with us. We came to Supreme Court, said, what do we do with 1,500 crores? Supreme Court said, paid all over again. Paid all over again.
Pro rata basis.
That is what, of course, pro rata.
And all this money is out of those 470.
that's right.
Out of the 470 million, increasing. Just see that so that, my lord, at least these facts, unless the government says this affidavit is wrong, and so far they haven't said it. If your lordship sees from page 2621, it will become very clear.
Just let us get the file.
I'm sorry.
वो 425 था वो बढ़ गया.
Yes, it is a thin file. Yes.
What page of this?
Starting 2621, in 3 pages, my lord, everything is, or at least this factual bit, your lordship will have a clear picture.
Yes. You've got it? Huh?
And this is as late as 2011.
26?
2621 onwards. I hope they've given the right file.
Yes.
Foot of the page, it says it submitted Government of India frame guidelines and quantum of compensation. Then it says guidelines originally issued by the government, 92, it gives your lordships the figures. It is further submitted, page 2622,
Yes.
that initially 6,18,659 cases were registered in the office of the director, claim. However, the settlement between the government and UCCIL was 89. In pursuance of the notification of 1996, registration of new claims commenced from December 96 to 7th February 97. So, it is not that the process took 7 years. They finished one round of registration. Then the government reopened the registration. That registration ran so and so. Further 60 days time was given for submission of forms. 410,000 new claim cases were registered in the Office of the Welfare Commissioner.
4,10,000.
Yeah, 4,10,000, sorry. Thus, in all, 10,29,517 cases were received. All these cases were disposed of by the...
Just one pausing as Mr. Salve for a second. 6,18,000 cases first
Yes,
is all that is received
yes.
over a period of 4 years.
89 to 96.
85 to 89.
Yes, 85 to
4
89.
years.
Yes,
Then after about 7-8 years, the claims are reopened.
Yes.
You can add to the claims.
yes.
Against that, another 4,10,000 claims
Correct,
are
correct.
filed.
Now, this is, my lord, in the, and your lordship knows, Welfare Commissioner is normally a sitting judge of the Madhya Pradesh High Court.
Yeah.
All these cases were disposed of by the Office of the Welfare Commissioner in accordance with the Act, out of which 574,376 claim cases were awarded.
So do we take it that the remaining cases were not found to
They were rejected.
rejected?
Yes.
They were not meritorious.
Yes. Now they may challenge that. That's the within
a
the
different
Act
thing.
process, etc. An amount of 1,548 crores have been disbursed as main compensation. 574,376 cases, old and new. However, 1,503 crores was left as surplus. It is submitted that the court, while deciding I 3181-38, directed to disburse the remaining 1,500 crores to the person whose cases have been settled and the pro rata basis, having due regard to the settled, unsettled and pending cases, the amount was disbursed amongst claimants. At this juncture, it would not be out of place to mention that the total amount of the settlement by the Honorable Court was for 70 million, which converted to Indian rupees amounted to 750 crores.
As on that date.
As on that date. In Union Carbide and so on so, the court held that no victim will be deprived of benefit to which he/she is entitled. If the settlement is found to be insufficient, the deficiency is made good by the Government of India. This is their affidavit. At the same time, the Honorable Court accepted the submission that while withdrawing the funds, the rupee deposit and the amount representing the accrued interest should be utilized progressively, exhausted, so that the benefit of any prospect of higher exchange rate may be preserved, and this was protect the interests of the victims in the event of increase. Thus, the Honorable Court never directed the amount of compensation to be determined disbursed with reference to the value of the dollar. Further, it is to be brought out that the claimants have been paid compensation twice. Initially, the original amount of compensation, and again an equal amount on a pro rata basis due to the augmentation of the money in the settlement fund deposited with the RBI on account of exchange rate variation and accumulation. These dual benefits of exchange rate variation and accrual have been availed by the claimants in the pro rata receipt. Then, my lord, see the next para at page
Just 1
260.
second. So therefore, what was the settlement of 750 crores on conversion of US dollar 470 million?
Became 3,000
At
crores.
the same time, became 3,000 crores,
Yes, 3,000 odd crores.
approximately.
Yes.
Out of which 1,500 crores were paid. But then with the passage of time, etc., 1,500 crores more left. Court said, okay, almost double it, or give it pro rata basis.
Pro rata again.
So
Yes.
again, that total amount is paid up to 3,000 crores.
Now, how it is paid is in page 2624.
Yes.
It is further submitted that in all 574, 376 cases were awarded compensation in categories 1, 2, 3, 4, and 5 within the framework of the Act. 5,21,333 cases were awarded minimum compensation of 25,000 in the 01 category. Further, 6,561 cases were registered in the death category but awarded.
These are only that same
Yes.
tabular which is given.
Correct.
The misconception which I had and which arising is that when they put the total figure, they put the total figure is about 748 crores or 750 crores.
Yes.
The fact is the fund disbursal is 3,000 crores.
3,000 crores. That was the
Not
gap.
48.
That's why, my lord, this explains it fully. He then says 40,000 cases of personal injury were awarded, 233 was done, 8 cases registered awarded.
next two-
Finally, by the order of this court, a 1-by-1 pro rata basis and equal amount was paid compensation. All the victims are availing of lifetime medical facility as provided by the government. It's also necessary to be brought out to the Supreme Court that the central government constituted group of ministers to examine the matters. The recommendation was as follows. Then, my lord, that is given. Yes, yes, yes. According to the group of ministers, following approach may be accepted, and an amount of 669 crores has been sanctioned as ex gratia to be disbursed amongst the following victims of categories. Now, in this, they have given the total number and said the total number of cases registered in death were 22,000, of which only 5,295 cases were proved as death during the adjudication and hence awarded accordingly. 608 cases were totally rejected as these claimants failed to prove their presence in the gas affected area at the time of the gas disaster. And the remaining 10,000 cases could not be proved as death cases due to exposure of MIC and awarded injury under 01. 10,047 cases under death which were awarded as injury after adjudication consists of 1,703 under permanent disability and 1,783 under temporary disability, for which the group of ministers has recommended grant of ex gratia at the rate approved for these categories. It is pertinent to mention here that the figures of categories mentioned in para 9 of ex gratia may be varied slightly as the claimants agreed by the lower authorities may approach appellate authority, etc. They have also recommended ex gratia at 5 lakhs of 42,000 cases. In addition, 582 crores has been released to the government of Madhya Pradesh for providing amenities like medical, economic, social rehabilitation, etc., etc. And then, my lord, he deals fully with the various numbers. Now, if the government of India says, look, this all is paid, but we want to pay something more ex gratia, of course you may. But you can't then say that the original settlement was that.
I think your mic will have to.
Please come back to page 2 of the note, and we have these figures, very important. So we were looking at those 1, 2, 3, 4, 5 categories, 1 to 5. Let us not look at laws of property, laws of livestock, which is about 1 lakh. We look at the other 1 lakh. So serial numbers 1 to 5 are 1 lakh set of people for whom the 725 crores was to be expended.
Yes.
But when the number went up to 5,74,000, you are looking at whether the amount earned interest or not by reason of an exchange ratio.
Total amount you paid additional 675
Now, instead of
crores.
being paid to 1 lakh and odd people,
Maybe any, the 725 crores.
could have been paid to them.
Became, according to an additional amount of 675 crores. Became due.
I'm coming to 675 a little late. I'm talking about this 725 was due and payable to 1 lakh and odd set of people. I'm not talking about the laws of property, laws of livestock. But on the other hand, this amount which accrued interest was paid to 5,74,000 people. Therefore, what I would have got if more number would not have been inserted in the number of claims, would have got more. Therefore, the
What
question,
you may have
therefore, the question was the number having
We actually
increased.
got by reason of Suppose the dollar rate would have remained the same, then what?
That would have been lesser. No, that's a different picture.
It would have been
I'm not on the dollar exchange issue. That would
There's
probably
lot of ifs and
completely.
buts in it. Ifs and buts can't do so. So
No,
you
that would be
actually got the
completely
fact
alien
that
to it.
You
No,
got
I am
3,000
not-
crores.
I am not
Fact
on
is you
the-
got 3,000 crores.
Kindly
by
bear with
reason
me, sir.
of The interest which the amount through LIBOR rates got in the RBI actually, and with the, and larger part would be actually less of interest, more of the exchange rate.
Everybody,
Which arose.
if
You
they,
got the- By fortuitous circumstance, instead of the exchange rate fluctuations,
if the,
what was available was
The
3,000
exchange-
crores.
the exchange rate would have made a difference only in the depression of the ultimate quantum. That's about all. I'm not looking at the exchange rate. That's not probably relevant at all here. That's
do you
only
say
for
it's
the
not
purpose of
relevant?
knowing how much
People
was
would have
actually
got
disbursed. That's about all.
People would have always got in Indian rupees. Compensation was not being determined in dollars.
Certainly, kindly look at from this
Therefore,
point of
when
view.
you say that people would have got 725 crores and 675 crore more has been spent by us because the numbers increased, other things increased, other factors came in, it still takes you to about less than 1,500 crores. That's why you satisfied the claim of everybody.
No,
What your
when
affidavit, the
in-
commissioner's affidavit
No,
says.
let me
you
have a small
satisfied
explanation.
the claim of everybody in about 1,500 crores, but with passage of time and other things,
That perhaps
the
require a
puppet
little,
fails. Let's deal with the remaining amount. What is to be done?
I'll correct, little
It's not a profit
clarification.
earning enterprise.
Come back
So
to page,
give double the amount almost, or pro rata vesa which was given.
please come back to page 2625, the little clarification, so that we have this basis clear. In 265, the affidavit read out, in 2010, the new ailments which came to be, found out. So the renal kindly see the figure. Kindly see, please, page
Say that
262. Please,
how
turn over to page
do the
2625.
ailments, some people may have ailments because of that. Some people may have other reasons. After all, the body is such a structural ailment. How do you
Please,
link the two
I
after
would
20
only,
years?
I would only
25 years?
advise,
Completely at loss, actually.
in para 9 at page 2624 and at page 2625.
Table is made very conveniently by your department. They talk about 725 crores. It's only when this affidavit is read that, at least for myself, I don't know others, that I came to know that there's 3,000 crores which has been disbursed.
Of course, but then to
But
what
of
number
course
of
it's not
people is
here.
the question?
We have
To
to get
what,
the of course for till this, of course,
to
the
what
affidavit was
number?
read.
No, to how many people is the question?
Your
The question is,
your argument is simple. You paid that 670 crores for being distributed to X
to
number.
how many number of people?
To X number of people,
Yes.
which was the figure which is given in column A. Now, whether because it was distributed late or for whatever reason there was exchange rate fluctuation, that should be all discounted and taken as distribution to 5,74,000.
No,
2 lakh,
that's precisely what I'm trying to
2
point
lakh
out.
5,000. 2 lakh 5,000. That's the figure. Which is given.
Let us keep it at 1 lakh. Forget about
Okay,
this.
okay, we
Right.
exclude 5, 6 and 7. So till 5, 1 lakh odd was the figure. So don't account for that while making distribution to the other persons who have come in, which is 5 lakhs and odd, or 4 lakhs and odd. So that's your, argument. We understand.
That's right. So in the process, if I would have got 1 lakh or a pro rata on versus the earning of interest, I would have got to 2.33 lakhs. Nobody ever got beyond that.
So what
Therefore,
you're
the whole,
saying is
if
if the interest and depreciation in Indian rupee takes place, it will only accrue to the.
was only a solace,
benefit
or the great solace,
the-
that's about all.
Yes, to the benefit of those 1 lakh.
So that earning interest
It's solace
cannot
to
by
them,
itself.
but it can't be an extra deprivation for the other side.
No, that would be a question I would probably urge a
That's
lot.
the whole problem.
That I'll try to urge the
They
question,
can't
that
come back
question.
and say, look, the exchange rate has gone up, now give us benefit. No, that's
they-
the settlement.
the
If the exchange
settlement-
rate doubles, it doubles.
I
You get the
would
benefit.
probably urge of your lordships to look back into the 1989 3 SCC,
Then-
which steers clear of all these peripheral aspects of the case. These are all peripheral aspects which ought not to have any bearing on the ultimate question as to what number the court will ultimately take into account, and if so, what quantum. That question is a core question, and that's why your lordship said we will spend enough time on reviewing this matter if those materials are brought before us. So we are on the materials. We are not on any other questions. So for the UCC to say, look here, you had the benefit of a exchange rate of interest and interest earning over a period of time, well, you could have used it for spending for 1 lakh or 5 lakh of people. I mean, how does it lie in their mouth?
A delict cannot come to the court and say, I had all kinds of delictual arrangements, I will walk out of my liability and jurisdiction, and that's the end of the matter.
They are saying you have settled, now you deal with it.
That's a
They are
problem.
not saying all this
So
you are
if-
putting to them.
if your
They are
lordship
saying
think,
you settled,
if
you
your
are Union
lordship
of India, you settled,
That's my long and short.
you have walked out of this, we have walked out of it.
nobody has walked
You-
out.
you-
I
you
with
agreed.
great respect.
Of course they walked out. And after that, if something more, you are supposed to make up with this.
No. If
The other facts which have emerged that actually the figures was not 700 or so because of fluctuation. They are not trying to take advantage of that fluctuation.
I am
What
the
we are
Union
trying
of
to
India,
put to you is,
please-
you have got 3,000 crores to disburse.
if your lordships say that somebody is trying to take an advantage, kindly look at, again, come back to paragraph 38.
Neither, it's not a question of advantage, that's a fortuitous circumstance in your favor. They can't claim anything. You've got it, we are
No,
not.
I only looking at para 38 as a proposition,
Yes.
which this court has said, with all its anxiety and concern built into it.
Yes.
If the court says, settlement notwithstanding, if a settlement has to be final, irrevocable, then the court need not travel this extra mile to keep it open. It kept it open. If it kept it open, then the court will only look at relevant reasons which will persuade the court on the basis of materials, supplemental information. And if those supplemental materials could have only come on record before the court by any process under the Welfare Commissioner's proceedings under the Act, then would they be told to wait at the gates and said, no, you have no entry. This court said you will have a necessary entry. You can't come in.
Question is, in what circumstance, what you consider as an entry, is there an entry or not?
No, therefore somebody could examine that. The Welfare Commission process is a statutory process. And your lordships, when
You are praying for a retrial of the suit. That is
no,
what you are praying.
if
You are
somebody
praying for
could
a-
say,
You are actually saying,
no,
let's
I'm only
try the suit again, starting from where it was, despite our having appropriated the amount. This is what you are.
yes, of
It's
course,
come in
of course, of
substance.
course, of course.
Then try the suit. Then he is saying, you say,
No,
walking out of the settlement, then there's obligation under the settlement doesn't remain. You look at both ways. See, you can't.
No,
have your cake and eat it.
if a settlement, again to go back, I mean, these are areas where the court will probably look at it entirely from a different perspective.
The government
A
of India
perspective
says
where-
that we don't have the means to come to figures for decades together. Therefore, we did not know what was happening. Now, some benefits may have come to us by reason of foreign exchange fluctuation. Ignore that aspect. That's a fortuitous circumstance. But now reopen the whole thing and try the suit. Then say try the
No,
suit.
then I ask myself a question, with respect to Lord. Ask myself a question. Is this that paragraph 38 written in vain? At what point of time the court thought a paragraph 38 would come alive? When will it come alive? It can come alive, and I'm sure it is not written in vain. And if it can come alive, it can come alive after the due process of law has reached certain termination.
Yes.
And that's how it happened today. So if the entire settlement is over, notwithstanding all these very, very eloquent concerns expressed in this judgment, nothing else remains. But the court was alive to this fact that materials will emerge. And in all those mass tort cases, materials always have emerged. And if the court were to say 25 years, 26 years have been consumed, and therefore somebody can be relieved of the wrongdoing. The wrongdoing is a wrongdoing, negligence once, negligence always. A wrongdoing always. You cannot say my wrongdoing is vanished because I'll be relieved of the liabilities because of the process of law and the consumption and the time which has elapsed over a period of time.
We can reopen after 100 years a settlement saying that.
They say it all depends. Your lords will draw
It
lines
is
on that.
happening 39 years, hence you are saying open this everything.
There are cases I'll show how when will reopen. I'll be able to show them. So if on materials which do not inspire confidence, and there are cases where you want
Actually,
an
it's not even
added
reopening.
amount of compensation.
It's not even reopening. You are not even saying, you can't say because you will be in great problem if you say reopen the settlement.
Revoke.
No.
The words are revoke.
Let us look into the.
You are saying add on the figures on the settlement.
I would
because
say
of, without
I
trial
would-
because of the material I put before.
I would say upon a fair and a comprehensive examination of other material going to place, this court will say, yes, that is possible. May reject, your lords may reject that question. But I'm saying that's what the court is being urged to do. Now, if you let us look at also what the review judgment, the actual review judgment had also seen that. So arguments were raised before the review court. And how did the review court look at that? So would you, like, before I take you lot to the review judgment, kindly turn to a few facets of the legislation. In the same volume, at volume 1, at page 182,
Yes. Now, where are you?
section 10,
Where are you taking us?
volume 1 of the same compilation,
Yes.
respondents compilation, the same volume.
Okay. Which page?
Page 182, section 10, clause. For the removal of doubts is hereby declared
This is of
that
the
any sums paid by the government to a claimant, otherwise than by way of disbursal of the compensation or damages received as a result of the adjudication of settlement of his claim by a court or other authority, shall be deemed to be without prejudice to the adjudication or settlement by such court or other authority of his claim to receive compensation or damages in satisfaction of his claim, and shall not be taken into account by such court or other authority in determining the amount of compensation or damages to which he be entitled in satisfaction of his claim. Therefore, what the government did by way of Croatia is covered by this.
Yes.
So in order to meet a contingency when people waiting for a long time, and then as page 6225, the affidavit shows there are new ailments with the process of a settlement commissioner found out. And the ailments which earlier were not even known, very serious ailments. People have suffered all this over a period of time. So in order to do that, this was done, and that's covered by section 10. So that would not be taken into account. And kindly look at the scheme. And the next page. It begins at page 183. And please turn over to page 186. Categorization and registration of claims.
The scheme is a part of delegated legislation, or it was a part of the original enactment?
It's
It's a part of delegated legislation?
Section 9 provides for a scheme. So 186, paragraph 5 of the scheme, on receipt of a claim under paragraph 4 of the scheme, the Deputy Commissioner shall, subject to the provisions of subparagraph 3 and subparagraph 4, the claim, appropriate category under subparagraph 2, and thereafter register the claim. The claims received for registration shall be placed under the following categories, namely, death, total disablement resulting in permanent disability to earn livelihood, permanent partial disablement affecting the overall capacity to earn livelihood, temporary partial disablement resulting in reduced capacity to earn livelihood, injury of utmost severity, then minor injury, then temporary dislocation of means of livelihood, claims of the government, authorities under the control of the government, local authorities and institutions for expenses incurred in providing relief, aid and rehabilitation to the person affected by the Bhopal Gas leak disaster, administration expenses incurred by the central government, government of Madhya Pradesh, local authorities to cope up with the Bhopal gas leak disaster, including all local and administrative expenses attributable related to the disaster. Then claims relating to loss of revenue to the government authorities. They were under the control of the government or local authorities. The next, claims on account of damage to fauna. And little later, K, claims on account of damage to environment, including pollution of soil, flora, fauna, and water system. Claims relating to loss and destruction of property. And N, claims in respect of injuries that are likely to be suffered on account of the Bhopal gas leak disaster. Therefore, it was even the scheme envisaged. There were certain diseases were likely to be suffered. How do we look at that? So the statute provided for an avenue. That's why Justice Mukherjee, in his judgment on the constitutional validity, He says, look here, suppose this little opportunity would have been proper. But to settle, to undo the settlement now, because settlement has been gone into, so what possible, results can flow from that? I'll take your lordship to the judgment. Therefore, the scheme and the act envisaged at that point of time, a scene which unfolded over a period of time. It's not as if, for instance, in the case of a wrongful injury, a wrong is caused and the injury is immediately perceived. Both the wrong and the injury come to an end immediately. We are not on those categories of cases. So an unfolding over a period of time of what may happen by reason of the gas leak. And that's why documents are placed to show the confidentiality that are maintained about the nature of the gas leak and the impact of the gas leak. A mere contact can cause a difference. Therefore, an unfolding over a period of time is what is implicit in the scheme or the act and the scheme. So can therefore somebody say, look here, the scheme had a tardy, process, and then did not do it efficiently and come to an end as early as possible. Therefore, a delegate can come and say, I find some refuge in your delay and lapses. I find it very difficult as a proposition of somebody to say, yes, I've committed a wrong, but there are some wrongs at your end in computing the compensation and in computing the number of persons who are entitled to, because as far as I am concerned, the settlement is the final word on the subject. I am not concerned about what's happening under the settlement process. So for the settlement process, you have so many issues, that's your headache. I wonder whether
settlement process
that's precisely what they're trying to say.
Settlement process is yours. You devise it to the best of your ability in trying to settle the claims of people. You have a corpus for money. Questions, can you? And what has been troubling us throughout is in a curative petition, you want some amount which you perceive by your figures to be there, you burden them with this amount. That's the curative relief. Without in any way challenging the settlement which is taking place. It is a valid settlement. You also know otherwise these monies would not have come to you. Now you feel that some more money can be got from them if you can get them. You say, get it and help us disperse this amount.
No, probably your lordship would like to go back at that point of time when the whole scene with agog with a lot of concern about how do we do immediate justice. I mean, I have appeared for some of the parties and sometimes for Union of India in different capacities. I finally have an idea of what happened.
Sometimes when you settle, it's like sometimes settlement of an amount in any other proceedings also which arise. People weigh that should we settle now, should we carry on litigation? This is of course a little different thing because of the nature of this.
Your lordship, right.
You weigh and then you, on the basis of what you weigh, you agree at a settlement. The sanctity of a settlement otherwise goes away. What's the signal we send that even if a government of India settles something, it will open tomorrow? Please look at a larger ramification.
I understand all that. I quite see that. I'm alive to all those dimensions of what I'm trying to.
More separate yet unipolar world in terms of trade and commerce. You say, well, even if you settle with us, it's not the end of the line. Well, tomorrow, if you like it, we can open anything. That's what is happening.
May I continue tomorrow?
Okay, tomorrow.
I may be missing for a little while in the morning.
I don't think he'll end in a little while.
I'm grateful to you, Lord.
हेलो ये 21 नंबर की आज जो लिस्टिंग फाइल थी ना उसमें रख दीजिएगा 21 की हमारे यहाँ का की गई 21 नंबर की जो फाइल है 3 जजेस वाली बेंच उसका कागज है तो ये सब चीजें
ये कुछ नहीं